Mr. Downer doesn't challenge the constitutionality of the Criminal Procedure Act or any other act of Parliament which applies to his criminal prosecution. He challenges the lawfulness of the prosecution itself. He says the prosecution itself is unlawful because it is an abuse of the process of court. And we make the submission that in the Moyo case, His Lordship Mr. Justice Wallace did not for a moment suggest that the long line of authority about how you challenge an abusive process is in any way inconsistent with what his findings were or in any way wrong. So that's the main case we've come here to meet, because, well, I shouldn't say we've come here really to meet whatever case Mr. Zuma wishes to present. But that's the main case which is presented on behalf of Mr. Zuma in his heads of argument. And we say that the case is entirely without foundation. In fact, Mr. Zuma has failed and failed again to answer the factual allegations which are made, and he has now failed and failed again to answer the legal submissions which are made. We've dealt with all of this extensively in our heads of argument, and with deference to what your Lordship has said, I'm not going to repeat all of this. Can I whiz through and just pick up some points which I need to amplify? As your Lordship and your Ladyships are aware, for the past 19 years, Mr. Zuma has made multiple applications to court with regard to the investigation of his alleged criminal offences and his prosecution. Not one of Mr. Zuma's case applications has succeeded. Every single one of them has failed. He launches his challenges one by one. Each one starts only when the last one was finished and has failed. He then repeatedly seeks leave to appeal, and then further applications for leave to appeal against the adverse judgments and orders against him. He made his first appearance in court on the 29th of June 2005, almost 18 years later. While his trial has formally commenced, it has not reached the stage at which any evidence has been led against him. And through all this process, Mr. Downer has been the lead prosecutor, and Mr. Zuma has attacked him in an attempt to discredit him and disqualify him. Your Lordship and your Ladyships know that in May of 2021, Mr. Zuma raised a special plea in terms of Section 106 of the Criminal Procedure Act, that Mr. Downer didn't have title to prosecute him. He did so on the basis of the very facts that are now before your Lordship and your Ladyships. The same facts. This court in October 2021 handed down an extensive judgment which dismissed the application with costs. Mr. Zuma applied unsuccessfully to his Lordship Mr. Justice Kuhn for leave to appeal. It was refused. He then applied unsuccessfully to the SCA for leave to appeal. It was refused. He then applied to the President of the SCA for reconsideration of his application for leave to appeal. It was refused. He then applied to the Constitutional Court for leave to appeal. It was refused. Now, he wishes to proceed with the same case in this court and ultimately in the criminal court. We say that simply can't be. We say this too, that the case now is weaker than the case which was before his Lordship Mr. Justice Kuhn, because what his Lordship didn't have before him was an affidavit which is now before the court by Mr. Breitenbach, Advocate Breitenbach, who says, I'm the person who disclosed the medical letter. I did it. I told Mr. Downer about it afterwards. Mr. Downer, I didn't ask Mr. Downer for permission to do it, and Mr. Downer didn't give me permission to do it. It was my conduct. That's really the end of the case. That now is before this court. And so, and let me say this, and it's undisputed. There's no evidence before the court to show that it is wrong. All that Mr. Zuma holds up, if he holds up anything, is, well, let's see what happens in the criminal court. There's some evidence. There might be some evidence in the criminal court. I can't tell you what it is. I'm not going to tell you what it is, but there might be some evidence in the criminal court. And we say that this prosecution is an abusive process. It's an abusive process because it's instituted for delay. It's part of the strategy, which was announced in 2007 by Mr. Zuma's counsel. and it was initiated for an ulterior purpose, which is related. So it's initiated for delay, to prevent the trial ever happening or to obstruct it happening. It's also for an ulterior purpose to stop Mr. Downer doing his job, which is his constitutional and statutory and professional obligation. And it's also an abuse of process because the case was without substance. And I've shown you the court, and I will briefly refer the court to the authorities to show that if the prosecution is without substance, is unsustainable, then it is an abuse to bring it. Mr. Zuma has, at least in one regard, been very frank with the court, because he's told the court what he's going to do next. He's said, I'm going to use this private prosecution to try to have Mr. Zuma removed from, to have Mr. Downer removed as a prosecutor. He says he's going to bring an application for the removal of Mr. Downer as the prosecutor, and the basis will be what? It'll be that he's being privately prosecuted. And so this private prosecution is not only to create delay by itself, it's to lay a foundation to be a springboard for further delay, to now have litigation about whether Mr. Downer should be the prosecutor. And if Mr. Downer declines to withdraw, and if the court says he's not obliged to withdraw, there'll be an appeal against that decision. And if that decision goes against him, then Mr. Zuma will apply for leave, and he'll apply for leave, and he'll apply for leave. And so this prosecution is not just an abuse by itself. It is an abuse which, on Mr. Zuma's counsel's own words, is the foundation for a further abuse which is yet to come, which is a challenge, an application to challenge Mr. Downer's position. And so no one can say we haven't been warned. We've been told we've been given an advance notice of what's going to come. And we say it is the clearest possible example of an abuse. At page 8 of our heads of argument, we quote what was said by the Constitutional Court in Laws for Human Rights about what is an abuse. I'm not going to take the court through all of that. What the court held was, it can be said in general terms that an abuse of process takes place when the procedures permitted by the rules of court to facilitate the pursuit of the truth are used for a purpose extraneous to that objective. And then we make the submission, paragraph 21 of our heads of argument, on the line of authority in the Supreme Court of Appeal and in the then Appellate Division, that it's also well established that it is vexatious and an abusive process to institute proceedings which are obviously unsustainable as a certainty and not merely on a balance of probability. And so the result is that the prosecution, the issuing of the summons, must be set aside. If it is an abuse, it must be set aside. And that's what was held in the famous Solomon case. What the court said, and I quote, "The taking out of the summons would clearly be an abuse of the process of the court, in that it had been undertaken not with the object of having justice done to a wrongdoer, but in order to enable the prosecutor to harass the accused or fraudulently to defeat his rights." Quite prescient words. The process of the court provided for a particular purpose would be used not for that purpose, but for the achievement of a totally different object, namely for the oppression of an adversary. Again, prescient words. The court has an inherent power to prevent abuse of its process by frivolous or vexatious proceedings. And it goes on to say that this can be done by approaching the court. This court, what he says, the court said, would, in my opinion, would by virtue of its inherent power be entitled to set aside a criminal summons issued by its own officials or to interdict further proceedings upon it. And so that is an abuse, and we say that is the cornerstones of why it is an abuse. We deal from page 11 with the proposition that there are no material disputes of fact. No dispute about this. No dispute raised in the heads of argument. Mr. Zuma does, however, say one very relevant thing, and we quote it at the top of page 12 of our heads of argument. He says in his answering affidavit, whether or not proceedings challenging perceived unlawfulness constitute Stalingrad is not judged quantitatively. In other words, it is not according to the number of cases I brought and according to the number of occasions my rights were violated. It must be judged qualitatively, according to the meritlessness of the challenge, which must lead to the inference of delay. And that's exactly our case, that these 20 years of meritless challenges lead ineluctably, unavoidably, inevitably to the inference of delay. All of Mr. Zuma's challenges have been found to be meritless for the past nearly 20 years. The conclusion one draws on Mr. Zuma's own proposition, correct proposition, is the inference you draw is that this is done for delay. Mr. Zuma makes the remarkable assertion, I have never brought a baseless and unsustainable application. Well, every one of the applications which he has brought has been found to be without foundation. So all of those courts and all of those judges, the Constitutional Court, the SCA and this court, are all wrong. These cases were in fact well-based and sustainable. It's just that the courts didn't understand them. So I've made the point that Mr. Zuma doesn't deal with doesn't address the facts, he avoids them. The facts of the case. What's actually going on in this case and what is going on in the proposed criminal prosecution. He makes blanket denials and he doesn't provide any facts which contradict what is said. Instead of doing that, after making the blanket denials, he says the following, and we quote some examples at page 13 of our heads. He says, in paragraph 35, we quote, he says, I carry no obligation to reveal the minute details of my evidence in the forthcoming criminal proceedings. Of course, he doesn't. It's not minute details of his evidence. He discloses no details of his evidence. All these issues will be fully ventilated during evidence and or cross-examination at the criminal trial. No useful purpose can be served in dealing with them in this application. I leave these factual issues for their proper ventilation in the criminal trial. The defences raised herein on the merits belong in the criminal proceedings. These are matters which ought properly to be raised during or at the end of the criminal trial. This issue is also being prematurely raised. It ought properly to be raised in terms of 106(1)(f). We make this following submission. The issue before the court, one of the issues before this court, is whether the prosecution is sustainable. Mr. Downer has made the case that it is unsustainable, that there's no basis on which he could conceivably be convicted of what he's being charged with. Where the issue before the court is whether the prosecution is sustainable, it can't be justified. The respondent can't justify it by saying, oh well, I'll justify it at the trial. I'll produce at the trial some evidence. I won't tell you now what it is, but I'll produce at the trial some evidence which will show you that the accused did actually commit the offence. In this court, where the question is whether the prosecution is sustainable, the court deals with evidence. Evidence must be produced to show that the prosecution is sustainable. Mr. Zuma has not been able to produce any. Then we deal with the preliminary objections. I've already dealt with jurisdiction. I'm not going to go there again. I've already dealt with the question of the State Attorney, Rule 7. But I do want to deal with the reliance that is placed on a judgment which was given by the Supreme Court of Appeal in one of Mr. Zuma's cases. Mr. Zuma will go down in the history of our country in many ways. One of the ways in which he will go down is one of the most persistent litigants our country has ever known. And what I want to show the court is what the case that Mr. Zuma relies upon actually says. There was a case in which the Democratic Alliance challenged the payment of Mr. Zuma's fees of his private attorney by the State Attorney. The State Attorney paid large sums of money, approximately 15.3 million rand, to Mr. Zuma's private attorney to represent him in the criminal proceedings and matters that went before it. Of course, those fees weren't all for the attorney, they were for counsel as well. And the Democratic Alliance challenged this and said there was no basis in the State Attorney Act for this to be done. And this is what the Supreme Court of Appeal held that the payments were unauthorized. Mr. Zuma relies on that to say, well, that shows that the payments to the briefing of the state attorney in this matter is also unauthorized. Well, there are two fundamental differences between it. The first difference is that in that case, what had happened was the state attorney outsourced the whole job to a private attorney. And this is what the SCA said about that. It said in paragraph 43 of the judgment, neither section 3.1 nor section 3.3 of the Act entitles the state to pay for Mr. Zuma's private legal costs in his criminal prosecution and related matters, as the presidency and the state attorney had believed. On its express terms, section 3.1 and 3.3 only permits the state attorney to perform functions. It does not authorize the state attorney to outsource its functions to a private attorney at state expense. Yet this is what occurred in Mr. Zuma's case. So what the court said at paragraph 43 is that all of this was unlawful because the state attorney can't outsource. There's been no under the State Attorney Act. There's been no outsourcing here. Mr. Downer is represented by the state attorney, we've counseled in the usual way, and so there's been no outsourcing at all. Secondly, and in any event, the court noted that there are circumstances in which the state attorney can represent somebody other than the government, where there's a public interest in the matter, and so on. And this is what the court said in paragraph 39. Whether the government or the public has an interest for the purpose of providing legal assistance by the State Attorney's Office must entail at least an assessment of the nature of the proceedings, the issues arising for determination, and whether there is a legitimate reason for government to support a position taken in the matter by a party other than the government. I dare say, the court goes on, that the government and the Republic can hardly have a legitimate interest in supporting a defense against criminal charges by an incumbent or former public office bearer, and especially not in the respect of charges of dishonesty and corruption. But all of these things, of course, would have to, if a Rule 7 challenge had been properly raised, then those are the sorts of questions which the court would have had to consider in deciding whether the state attorney was authorized. The court would have had to examine, in the words of the SCA, an assessment of the nature of the proceedings, the issues arising for determination, and whether there's a legitimate reason for government to support a position taken in the matter by a party other than government. That's what would happen if a proper challenge was brought. The court said to fall within the scope and ambit of section 3.3, it must be evident that the performance of functions by the state attorney in matters where the government is not a party is justified by the government's interest or concern in the matter, or that it's in the public interest that the state attorney assume the functions. That's paragraph 37. So those are all questions which would arise if a proper Rule 7 challenge was brought. Mr. Zuma would be entitled to say, this has got nothing to do with the government interest or the public interest or the state interest, and it's an abuse of funds, it's an impermissible use of government funds for the state attorney to represent Mr. Downer. Mr. Downer would have been able to come to court and say, this is why it is in the interest of the government, and why it's in the public interest that I be properly represented and represented by the state attorney. Your Lordship and your Ladyships have heard no argument on that, and will hear no argument on that, because there is no proper Rule 7 application before the court. If there had been, there would have been affidavits filed dealing with all these questions, and your Lordship and your Ladyships would have been in a position to decide it. But none of this is before the court, because there's no proper Rule 7 challenge raised. It's just thrown into the pot, as it were. It's illegitimate, it's dead from the outset. It's simply not before the court, and it just sits there. Then the question of the non-joinder of Ms. Maughan. I don't know whether your Lordship and your Ladyships have seen Ms. Maughan's letter, in which she says she does not wish to participate in Mr. Downer's case. She has elected not to participate in his case. To the extent that she has an interest, she chooses not to participate in Mr. Downer's case. And my learned friend for Ms. Maughan will no doubt confirm that she does not wish to be joined in Mr. Downer's case. So the complaint of non-joinder is irrelevant. If a party says, I don't want to participate, then no question of no non-joinder can arise. To the extent that she had a right to be joined, which we say isn't the case, she has waived that right. So that complaint is also just another attempt to create a roadblock instead of dealing with the substance of the case. And I'm sorry to have to say this, but I must say it. That is what characterizes the position of Mr. Zuma throughout this case. It's an attempt to throw up roadblocks rather than to address the substance of the case. That brings me to the question of why the charge against Mr. Downer is unsustainable. We deal with this in our heads of argument from page 22 onwards. We deal with the facts in detail, but I'm not going to go through them because the facts, there's a very short answer to the case. Your Lordship and your Ladyships will remember that the case against that in the charge sheet, in the summons, the case against Mr. Downer is that he's an accessory after the fact, that he sanctioned what Mr. Breitenbach had done in disclosing the information to Ms. Maughan, and Mr. Zuma's case is that was an offence committed by Mr. Breitenbach, and Mr. Downer was an accessory after the fact. We say two things in that regard. The first thing is that Mr. Breitenbach did not commit an offence, and we've set out in detail why that is the case, and I don't propose to trouble the court by going through that detail. But secondly, we say even if Mr. Breitenbach did commit an offence, there is no possible basis on which one could find that Mr. Downer is an accessory after the fact, given the known facts and the inconsistent known and undisputed facts. The known and undisputed facts are the following. Mr. Breitenbach gave the information to Ms. Maughan. Secondly, he didn't ask Mr. Downer for permission to give the information to Ms. Maughan. Thirdly, after the event, he told Mr. Downer what he had done. Full stop. That's the evidence. Mr. Downer says that's the case, and Mr. Breitenbach says that's the case. There's no evidence to contradict it. Now, the extraordinary statement assertion is made in the charge sheet that I beg your pardon, in the answering affidavit, that Mr. Zuma says that, quote, by being informed, close quote, by being informed of the arrangement between Mr. Breitenbach and Ms. Maughan, Mr. Downer associated with himself with or failed to associate with the crime committed by Mr. Breitenbach. And if I can just give your Lordship and your Ladyships the reference, it is Mr. Zuma's answering affidavit, paragraph 69, page 241, where he says that the offence he committed the offence by being informed of the arrangement. There's no such offence in our law. There's no offence in our law of knowing of an offence committed by somebody else. It doesn't exist. And it goes further than that. That's Mr. Zuma's case. Mr. Zuma says that by being informed, he associated himself. But if one looks at what an accessory after the fact is, because that's ultimately what is relied upon, if I can refer the court to Lawser, volume 11, the third edition, that's the volume dealing with criminal law. This is what Lawser says an accessory after the fact is. An accessory after the fact is a person who, by his or her intervention, not knowledge, by his or her intervention, after the commission of an offence, assists the perpetrator or accomplice in evading detection of and prosecution for the offence. So that's what an accessory after the fact is. An accessory after the fact has to do something, not just know something. The accessory has to intervene to assist the perpetrator or accomplice in evading detection or prosecution. And then in the second paragraph, this is paragraph 136 of Lawser, volume 11, the second paragraph within that paragraph says the following, and it's with respect to the end of the case. Mere failure to report the commission of an offence or mere approval of an offence is not in itself sufficient to render a person liable as accessory after the fact. So even if you assume that when Mr. Breitenbach told Mr. Downer what he had done, and assume that this was a crime, even if you assume that Mr. Downer said, "Well done, Breitenbach, this is great work, keep up the good work," that would not be an accessory after the fact, because approving of the commission of the offence doesn't make you guilty as an accessory after the fact. And the authorities are clear. It starts with the appellate division. I'm sorry to say that there's another ancient authority quoted from 1937 in the appellate division, and then they quote case 1986 in the Cape Division and 1986 in the Cape Division. Mere knowledge is nothing. Mere approval is nothing. And so even on the case pleaded by Mr. Zuma, even if all of that is true, even if there was an offence, even if he said, "Well done, Breitenbach, I'm so pleased, congratulations," nothing would turn on it. Of course, there's no evidence that any of that happened. I do need to refer to one other matter which is in the heads of argument in this connection, because they make a most remarkable assertion, and I need to scotch it to make quite sure that there's no confusion. If Mr. Zuma's counsel are confused, it's important that the court should not be confused. It's the heads of argument of Mr. Zuma. It's at page 30. Paragraph 84. And this is what Mr. Zuma's counsel say. Is your Lordship with me? Page 30 of Mr. Zuma's heads of argument, para 84. In the present case, quote, "In the present case, on Mr. Downer's own version, the case against him is a strong one, he leaked a document written medical confidential to a journalist in violation of section 41 of the NPA Act," close quote. Now that's simply untrue. Paragraph 84 of Mr. Respondent's heads of argument in the related applications of Mr. Downer Ms. Maughan. Consists of 2 lines. There were 2 versions of the heads of argument. This is the later version which was produced. Well, could your Lordship have a look to see is there a heading, "Is the prosecution based on ulterior purpose or motive?" That's a separate thing. That's the other heads of argument. Just looking at the previous page. So. Well, I don't know. Apparently para 80, I'm told. Yes, it's paragraph 80 of the version that your Lordship has. Thank you very much. This, which is paragraph 80 of the 84 of the version I have. If your Lordship and your Ladyship will go to the 3rd sentence, the 3rd line, I beg your pardon, paragraph 80. In the present case, on Mr. Downer's own version, the case against him is a strong one. He leaked a document written medical confidential to a journalist in violation of section 41 of the NPA Act. Now, it's common cause on the facts that Mr. Downer gave nothing to the journalist. It was Mr. Breitenbach who gave it to the journalist. And he gave it to the journalist, what's more, without Mr. Downer even knowing about it. So on what basis our learned friends can make the submission that on Mr. Downer's own version, he leaked a document written medical confidential to a journalist, leaves one a bit startled. But let me just put this beyond doubt. There is no evidence to show that. The evidence is directly to the contrary, which is that Mr. Downer gave nothing to Ms. Maughan. That's what Mr. Downer says, that's what Mr. Breitenbach says, that's what Ms. Maughan says, and that's not contradicted in any way. Where the facts are inconvenient, other facts are created or alleged. And that's really, with respect, the end of the argument about the charge in respect of the so-called leak to Ms. Maughan, because it had nothing to do with Mr. Downer, and Mr. Downer can't be an accessory after the fact by simply knowing about it after it happened. And nothing is alleged. It's not alleged that he did anything to further Mr. Breitenbach's protection. And that's then one comes to the Nduchwa letter. I'm not going to go through all of that with your lordships and your lady. Your lordship and your ladyships have all of that. The fact of the matter is the letter of Mr. Nduchwa, of Dr. Nduchwa, was given to Mr. Downer by the relevant correctional services official. It was placed before the court in two forms. It was placed before the court by the NDPP in an affidavit, and it was placed before the court by Mr. Zuma's attorney in an affidavit. There's nothing secret about it. There never was anything secret about it. And we refer, can I just draw the court's attention to what His Lordship Mr. Justice Kuhn said? I'm not going to take your lordship to the detail. It's at paragraph 89 of our heads of argument. We quote in detail what was held by His Lordship Mr. Justice Kuhn, who investigated the very same question, whether this was some sort of breach of Mr. Zuma's rights. And I will read only one half of a paragraph on page 30 of our heads of argument of what His Lordship Mr. Justice Kuhn said. He says the only inference is that the intention at that point, that's attention of Mr. Zuma's counsel, was that the letter of 8 August 2021, that's Dr. Nduchwa's letter, would form part of the application for a postponement pursuant to the terms of my directive, which would mean that it would become public when filed. That would be inconsistent with the protestations that the letter was a confidential document, of which the confidentiality, if in fact it was confidential in the first place, was not waived. And of course there's nothing in the letter which is confidential. So if my learned friend tries to resuscitate the Nduchwa issue, I will deal with it in reply to the extent necessary. Then there's the charge, the disclosure to Mr. Sol, which is the most remarkable complaint. This arises from events which took place in 2008. And there were telephone conversations between Mr. Sol and Mr. Downer. Now, all of those conversations, that recording was unlawful, and the evidence would be inadmissible. Let me say that immediately. We don't know whether those recordings are genuine. We know nothing about that. All we know is that this is an attempt to introduce, it will be in the criminal case, an attempt to introduce some inadmissible evidence. But taking it at face value, let's assume this is a genuine recording. Let's assume it's an accurate recording. Let's assume there are no cutting out of inconvenient paragraphs or inconvenient sentences. Let's assume all of that. That does nothing to provide a basis for a charge against Mr. Downer. The first thing we say in this regard is the following. Why is this event of 2008, which Mr. Zuma knew about at least in 2009, why is it suddenly raised now as a criminal charge, 15 years later? What's the reason why this old car is hauled out of the slit 15 years later with a complaint, Mr. Downer breached my rights in 2008. Of course, the reason why it's done now is because the prosecution is now almost a reality. The prosecution is nearly about to happen. And so this old car is hauled out of the slit in an attempt to obstruct and delay the prosecution. That's all it's there for. And where this is alleged in the founding affidavit, Mr. Downer says, why are you doing this now? This is an attempt at delay. Mr. Zuma's answer, we quote it at paragraph 94. Mr. Zuma's answer is, I leave these factual issues for a proper ventilation in the criminal trial. He doesn't say, this is why I haven't done anything for 15 years. I forgot about it. I had a bad lapse of memory. I wanted to bring a charge, but my lawyers said I couldn't bring a charge. Nothing of that kind. He doesn't answer it. He says, I leave these factual issues for a proper ventilation in the criminal trial. Secondly, so that's the first reason this is plainly an abuse. Secondly, Mr. Downer points out that he didn't in fact disclose any information to Mr. Sol which related to Mr. Zuma's case. We've searched in our colleagues in the founding papers and in the answering papers and in the heads of argument for an explanation of what is this terrible information relating to Mr. Zuma which was disclosed. There's none. All that happened is Mr. Downer explained how the NPA obtains mutual legal assistance from other countries, and Mr. Zuma does not dispute that. Thirdly, they're in the wrong court. This offence is alleged to have been committed in Johannesburg. Why a charge is instituted in this court is not explained. Fourthly, this court, through His Lordship Mr. Justice Kuhn, considered this specific complaint and charge. And what he said was that Mr. Zuma's accusations were, quote, based on speculation unsupported by inadmissible evidence from Mr. Zuma. That's what this court found. Fifthly, Mr. Kuhn said that His Lordship Mr. Justice Kuhn said that in the stay application Mr. Zuma waived any reliance on these so-called leaks. And he says he can't rely on them now. The answer from Mr. Zuma was, oh no, that was a tactical decision at that time. I'm not bound by a tactical decision which I took then. Finally, His Lordship Mr. Justice Kuhn held that it was prima facie lawful for a prosecutor to deal with inquiries from the media as Mr. Downer had done. The charge relating to Mr. Sol is a leak to Mr. Sol, which is nothing of the sort, is obviously unsustainable, and it's an abuse, and it demonstrates the ulterior motive in the private prosecution. The Sol prosecution is, I was about to say it's breathtaking, but so is the Maughan prosecution, so Maughan charge, so they're both breathtaking. They're an attempt to create an issue where none exists. In their heads of argument, in a desperate attempt to justify the prosecution, Mr. Zuma's counsel referred to findings which Justice Kampepe made about leaking by the then Directorate of Special Operations. And that is supposed to prove that Mr. Downer engaged in an unlawful leak to Ms. Maughan or to Ms. Sol. The logical connection between those two propositions escapes us. Proposition 1, the DSO, Justice Kampepe says the DSO used to leak information. Proposition 2, therefore Mr. Downer leaked information unlawfully to Ms. Maughan and to Mr. Sol. The logical connection is lacking. We make the point, it's a desperate and hopeless attempt to resurrect a case. We make the point that the Directorate of Special Operations ceased to exist 14 years ago in 2009. Whatever it may or may not have done, it has no bearing on what Mr. Downer did. If you want to prosecute somebody criminally, you have to prove what he or she did, not prove what someone else with whom there's a form of association 14 years ago did. So the reliance on Justice Kampepe's finding is, the relevance of it is escapes us. So let me then come to a conclusion. We say that, we deal with it in page 34, we say Mr. Zuma doesn't satisfy the requirements for standing. Firstly, he hasn't proved any injury that he suffered as a result of the release of the document to Ms. Maughan. It was going to be released anyway by his own attorney. It was nothing confidential about it. And His Lordship Mr. Justice Kuhn found, I'm not persuaded that the disclosure of the letter constituted an actionable violation of Mr. Zuma's rights. This can't be re-litigated now in the criminal court. Second, that's as far as the Maughan disclosure is concerned. Secondly, as far as the Sol disclosure is concerned, Mr. Zuma doesn't say that he suffered any injury by what Mr. Zuma said, or by what Mr. Downer allegedly said to Mr. Sol in 2000 and whenever it was, 8. He makes no allegation of an injury. A person who wants to bring a private prosecution must allege and prove that he suffered an injury. There's no allegation at all of an injury in relation to the Sol matter, and there's no evidence of any injury at all in relation to the Ulterior matter. So we summarize our position at page 35, and with the leave of the court, I will take the court through that. We say, to summarize, and let me just say that this summary, none of this is actually answered by Mr. Zuma in his heads of argument, or for that matter in the answering affidavit. All of these things the submissions I'm going to make are undisputed. We say, firstly, the private prosecution is an abuse of the process of court aimed primarily at achieving further delay. The fact that it is an abuse is demonstrated by the following. First, it is paragraph 106.1, it is part of the Stalingrad strategy, which Mr. Zuma's counsel announced in 2007 that he would undertake. That is what his counsel said, and Mr. Zuma has never repudiated that statement. What he has done is he has implemented what his then counsel said. Mr. Zuma says that what I'm doing is not Stalingrad, but he's never said, I don't know why the late Mr. Kemp made such a statement. When I heard about it, I was shocked. I said to him, why do you make such a statement, Kemp? I publicly said, this is not my position, it's Mr. Kemp's position. Nothing like that. He didn't distance himself from it in any way. Secondly, this prosecution is part of a litigation campaign of nearly 20 years in which this court, the Supreme Court of Appeal, and the Constitutional Court have all found that all of Mr. Zuma's complaints, his applications, were groundless and meritless. Thirdly, perhaps the clearest example of the ulterior purpose is the raising of the complaint about events in 2008. No explanation is given to this, except that an explanation will be given in the criminal trial, apparently. The obvious reason is that Mr. Zuma's criminal trial is finally commencing, and he's desperate to invent another reason for stopping it in its tracks. Fourthly, we make the submission the charges in relation to Ms. Maughan are obviously unsustainable at a factual level. Mr. Downer didn't make the disclosure, he didn't authorize it, he knew of it only after it had been made, and he did nothing after it had been made to try to conceal it or to prevent a prosecution of Mr. Breitenbach for this alleged offense. He can't be an accessory after the fact, merely because he knew about it, he heard about it. Fifthly, the charges again in relation to Ms. Maughan are obviously unsustainable at a legal level because there is no offense which consists of learning about an offense, and in any event the disclosure was lawful. Sixthly, the charge relating to the 2008 disclosure to Mr. Sol is also obviously unsustainable. Mr. Downer didn't disclose any information relating to Mr. Zuma's case. The court doesn't have jurisdiction to deal with the offense, and the complaint has already been considered and dismissed by this court per His Lordship Mr. Justice Kuhn, and Mr. Zuma has previously expressly waived reliance on this disclosure, and it was lawful. Paragraph 106.7, we point out that this court has already found that there was nothing confidential in the medical letter from General Ulterior, that Mr. Zuma himself intended to place that letter before the court, in which event it would have been a matter of public record, and that Mr. Zuma's attempt to explain the events on the basis of a claim, a hearsay claim, that the dates on the letter and accompanying affidavit were incorrect is false. Ladyship may remember that the letter of General Ulterior and his affidavit are dated the 8th. The relevant date was the 8th, and all of these are 8th of August 2021. And all of this goes to show, we say, that it was contemplated that this would be placed before the court on the 9th. Mr. Zuma says, oh, those dates, the date on the date on the letter, the date on the official date stamp, and the date on the affidavit signed by the Commissioner of Oaths are all wrong. It should have been the 9th. But he doesn't produce any evidence to show that. It's the purest form of hearsay. So we say that this prosecution is an attempt to relitigate the findings of this court as to the validity of the complaint about the disclosure to Mr. Sol and all of these other matters I've dealt with. It's an attempt to harass Mr. Downer and prevent him from carrying out his duties. It's unsustainable. It's launched for the purpose of further delay. and preventing or obstructing Mr. Downer's performance of his duties. And this is the latest in a 19-year series of legal manoeuvres, every one of which has been found by the courts to be without merits. I'm sorry to finish on a sour note, but there is a matter which I need to raise in relation to what Mr. Zuma's counsel said in this matter. Can I take the court to page 31 of Mr. Zuma's heads of argument? And now I'm going to try to make sure we have the same version. And the copy I've got, it's page 31, and it's paragraph paragraph 86. It's a paragraph stating it is not a legal requirement for a private or public prosecutor.
82.
Paragraph 82. Thank you very much. Could I ask the court to go to paragraph 82 of Mr. Zuma's heads of argument, and to go to the 1, 2, 3, 4, 5, 6, set to the 7th line of that paragraph. Is the court with me? It's a sentence, it's a phrase which starts, "There is ample evidence." Does the court have that?
Please.
7th line of paragraph 82. Previously known as 86, aka paragraph 86. It goes as follows. There is ample evidence that that's Mr. Downer's prosecutorial crusade against him, Mr. Zuma, is motivated by personal interests. It is inexplicable how a so-called senior and competent prosecutor is unable to see the criminality and injustice of conducting this flawed criminal prosecution against Mr. Zuma. But because he is blinded by the false accolades he receives from his friends and enemies of Mr. Zuma. Now that is what is said by counsel about the present applicant. There is no evidence of any kind before this court to justify such an allegation. None. It is an allegation which is without any basis in the evidence. It is an allegation which is defamatory, which is gratuitous, which is offensive, and which is insulting, and which is injurious. And there is no lawful basis on which such a statement could be made, because there's no evidence to justify it. It's sucked out of someone's thumb. We think, Mr. Counsel, we invite Mr. Zuma's counsel to withdraw the statement and to apologize for it. It is a serious defamatory slur on Mr. Downer with no basis in fact. It's not privileged, because privilege only arises where there's some fact before the court on which a statement can be made. And so the privilege doesn't arise, and it is a serious, inexplicable burst of poison which is unjustified. And if our learned friends wish to be guided as to the law in this regard, I know it's another ancient case that goes back to 1967, but it's a famous and well-known case, decision of the appellate division in Utah, a famous prosecutor in our country. Utah versus Pogrund, 1967, Part 2, South African Law Reports, page 564, appellate division at page 570. We say that was a case in which Mr. Utah, then the Attorney General or the Deputy Attorney General, defamed a person who was a witness in a trial, was a party to a criminal prosecution. And the court said you can't do that unless you've got a factual basis for making what in that case was scurrilous allegations about Mr. Pogrund and about Mr. Pogrund's motives. So we invite our learned friends, quite seriously invite them. This is not said as a debating point. These sorts of things shouldn't be said in our courts. and we invite them to withdraw it and apologise for it. Finally, my lord and ladies, we say this case is important, not only because it's part of a continuing attempt to stop or delay the prosecution of Mr. Zuma. It's also important because this case is an invitation. This conduct, if it's upheld by the courts, will be an invitation to other accused to do the same thing. We will have case after case in which well-resourced accused persons who don't want to face their charges will prosecute their prosecutors, institute private prosecutions on trumped-up charges. And they will do so, and they will run those cases through the courts, and what they will do is they will obstruct the course of justice. This court, with respect, needs to say that this is not, what has happened in this case is not within the bounds of what the law permits. This was an abuse, it was an unlawful abuse, and it can't stand. We submit that the courts have a duty to prevent the abuse of their process, in order not only to protect their process, but to protect public confidence in the courts. This sort of thing makes a mockery of the courts, and it ought not to be countenanced. We submit that the summons issued by Mr. Zuma should be set aside, that Mr. Zuma should be interdicted from pursuing any private prosecution against Mr. Downer on substantially the same charges. That's the way to put an end to the abuse. We submit that Mr. Zuma should be ordered to pay the applicant's costs, including the cost of two counsel, on the scale as between attorney and own client. Where there's an abuse, the courts will punish it with an appropriate order for costs. This can only be described as an abuse, and we ask for an order on this, of costs on the scale as between attorney and own client. My lord and my ladies, those are our submissions, unless there's anything court would wish to raise. Yes, exactly. Thank you. Insist. Say again?
I think the code is working from the old heads, not the updated ones.
No, we've got the...
Yeah, but the reference when Jeff was referring to paragraph 84, the judge had it at 80, and it's 80 in the old ones, not the...
Okay, we'll figure it out.
To add, save for this. It is striking in our submission that what has happened in this case is an attempt by Mr. Zuma to resort to really technical issues in an attempt to avoid the merits. And we don't wish to repeat what's been said on jurisdiction. It's been put to bed comprehensively in our submission. And we also won't repeat what's been said on subsidiarity, except to say that even if there were some basis for subsidiarity, and there is not, the point is an afterthought and an attempt to distract from the merits issues. But even if there were something, somehow, in the subsidiarity point, our courts have made clear again and again and again that subsidiarity is not a hard and fast rule. It is not a rigid or inflexible approach. And if there were ever a case that cried out to be determined on the merits, it is this. And if needs be, I can give the court the authorities from the Constitutional Court in reply. But I won't go further on that. So against that backdrop, we propose to deal with the three main issues in our heads, which is the question of the noli prosequi certificate, then secondly, the abuse of process, and then thirdly, the lack of standing. In doing so, we face the similar difficulties to counsel for Mr. Downer, because the points have, on the whole, not been met in the heads for Mr. Zuma. But what's more, the heads for Mr. Zuma are notable in that they do not cite the record once. So you have these extraordinary statements about what the facts are, but you cannot find where they are sourced in the record. And there is simply, as I count it, not one footnote or reference to the record and the papers. And that is, with respect, most unfortunate, because we are on paper here. We know that Plascon-Evans operates, but what Plascon-Evans requires is it requires the allegations to be dealt with meaningfully in answer if there is a dispute of fact created, and in this case that has not been done. And what that means is that the facts that I'm going to take you to are effectively uncontroverted, and they must be accepted for purposes of this application. And it is no answer, let me say, to say, well, I will deal with them later at the criminal trial. It might have been interesting if the answer had been, well, my answer is X or Y, but we'll deal with it more in the criminal trial. With respect, that's not what's done. It is simply a bald suggestion that we will deal with it in the criminal trial. So could I begin then with the certificate of noli prosequi? And my Lord, His Lordship presiding has made clear that the bench has read the heads and read the authorities, and I will not belabor the point or read the heads. I simply wish to pick out a couple of points in order to demonstrate the highlights. Now, on the certificate of noli prosequi, you will know, members of the court, that this is not a point that is raised by Mr. Downer. It is a point that is raised by Ms. Maughan. And the bench will be well aware of the provisions of section 7.2a of the CPA, which provide expressly that no private prosecutor under the section shall obtain the process of any court for summoning any person to answer any charge unless such private prosecutor produces to the officer authorized by law to issue such process a certificate signed by the Attorney General. That means that the certificate is a jurisdictional prerequisite. If you do not have the jurisdictional the certificate and you have not met that jurisdictional prerequisite, you cannot proceed. Now, there is a faint suggestion in our learned friends' heads that that might somehow be unconstitutional, and that strict adherence to that would be unconstitutional. With respect, we don't understand the point. It's never fully explained. But that is truly an example of subsidiarity, because that would be an example where the statute says you require a certificate noli prosequi, and there's no challenge to the statute, and the statute must be accepted as a given. You can't challenge it via the back door. So we can accept, and the bench can accept for present purposes, that you have to have a certificate noli prosequi in place before you commence. Mr. Zuma relies on two certificates noli prosequi. The first one is the one that was issued before the proceedings began. We have dealt with it at paragraphs 16 through to 23. I will not repeat that, but I do make the following points. That certificate, on any basis, is plainly not about my client, Ms. Maughan. And it is not about my client, Ms. Maughan, because there was never any criminal complaint directed at her. Mr. Zuma did not name Ms. Maughan as a suspect or an accused in his criminal complaint, and at an announcement of the intended prosecution by Mr. Manyi, no mention was made of Ms. Maughan at all. And then we come to the letter to Mr. Zuma's attorney, Mr. Ntanga. The letter was written by the DPP, which expressly confirmed that the first nolli prosequi certificate did not apply to Ms. Maughan. You will see that from paragraph 18.1, where we have quoted from Annexure JZSA2, and that makes clear that Advocate Zungu wrote, "When I took the decision in respect of the aforementioned matter, the suspect under consideration, as expressed by the complainant, was Mr. Downer. Based on the investigations conducted and the evidence in the docket, I declined to prosecute Mr. Downer. Ms. Maughan was not contemplated as a suspect, but rather only a witness. If I am now required to decide whether to prosecute her, I require full investigations to be conducted before I make such decision." Now, with respect, that's the end of the first certificate. You have the words of the relevant DDP making clear that the certificate was not in respect of Ms. Maughan, and that really is the end of the first certificate. In an effort to avoid this, we get the supplementary affidavit from Mr. Ntanga suggesting that the first nolli prosequi certificate did apply to Ms. Maughan because the police took a statement from her as a suspect. But as we demonstrate in paragraph 21, that is simply false. And it's extraordinary with respect that the statement was made under oath, because as Ms. Maughan explains, she was never a suspect. She never had any contact with the SAPS and was never called to make a statement to the SAPS at all, let alone in a capacity as a named suspect. Instead, what happened is she was asked by the DDP to give information in relation to the criminal matter registered against Mr. Downer. And she discussed it with the editors, the News 24's legal advisors, and she gave an affidavit. So with respect, the attempt to portray Ms. Maughan as a suspect is simply without any merit, and there was nothing in it. I'll come in a moment to why Ms. Maughan was added, and we'll get there. But for the moment, it's clear that the first certificate does not apply to her. That then leaves the second certificate. And the second certificate is the one that Mr. Zuma's attorneys put up in the supplementary affidavit, and it's the second nolli prosequi certificate. Now, with respect, that certificate also doesn't resolve the fatal flaw, and it doesn't for two separate reasons. The first, and that's the point we make at paragraph 26, is that the second nolli prosequi certificate cannot cure the absence of a nolli prosequi certificate because it was not in place at the time that the summons was issued. Now, when you are dealing with a jurisdictional fact, which has to be met, and section 7.2a makes clear that it has to be met, you have to get it in place before you issue it. So on that basis alone, what the second certificate does or does not say is utterly irrelevant, and the charge against Ms. Maughan, the summons against Ms. Maughan, falls to be dismissed. We've referred the court to the judgment in Nundalal, which makes clear that and I quote in paragraph 26.4 of the heads, that the scheme of section 7 is such that the DPP must issue the certificate before the private prosecutor can begin a prosecution, and manifestly production of the certificate is a peremptory statutory prerequisite for a private prosecution. Now that, with respect, is the end of the case, but it's not answered by our learned friends. There is no attempt by them to grapple with the point, even though it is patently irrelevant. Secondly, even if this court was somehow to leave that aside and focus on the merit of the wording of the certificate with respect is by no means clear that it refers to Ms. Maughan, and we submit that it doesn't. We've quoted the certificate at paragraph 27.1. This is the second certificate. And it says, "I, Elaine Zungu, duly appointed DPP, hereby certify that I have seen all the statements and affidavits on which the charge particularized below is based, and I decline to prosecute any person in connection with this matter at the instance of the state." Now, with respect, the phrase "any person in connection with this matter" has to be understood in light of the fact that it's the statements and affidavits on which the charge is based. Could I give the court an absurd example? Suppose that Mr. Zuma decided to prosecute me for this charge and decided that I had somehow been complicit. I was not, let me hasten to add, but that I was somehow complicit. I would be able to respond by saying, but there is no nolli prosequi certificate in respect of me. And it would not be open to Mr. Zuma to say, no, but we had the certificate of November 2022, and that says that the DPP doesn't intend to prosecute anyone. With respect, my name was not mentioned in the docket. It was not mentioned as a suspect, and so the DPP couldn't have given proper consideration as to whether I was going to be prosecuted. Similarly, Ms. Maughan, although she has more connection to the events than me, is not mentioned as a suspect. She's not mentioned as the subject of the criminal charge, and therefore she is not a person in respect of whom in connection with this matter, because it must be understood that that was a reference to prosecutors and investigators. So even if this court were somehow to overlook the fact that the second certificate is too late, and let me be clear, there is no basis to overlook it, that is the end of the point. But even if the court were somehow to overlook the fact that the second certificate is too late, the second certificate doesn't fix the gap, and that, with respect, is the end of the case against Ms. Maughan. Because absent a certificate of noli prosequi, Section 7.2a of the Criminal Procedure Act has not been met, the jurisdictional prerequisite has not been met, you cannot cure it, and that is the end. So if I sat down now, at this point, this court would, with great respect, have no option but to uphold Ms. Maughan's case, to set aside the summons, and as far as Ms. Maughan is concerned, she could go home. Now, it's... you took the words out of my mouth, my lord, because I was going to say it is tempting, therefore, to sit down, but there is a difficulty. And the difficulty arises, and I mean no criticism because it's plainly correct, the difficulty arises from what I will call the Spillhouse principle. And the Spillhouse principle is the principle enunciated by the Constitutional Court, which says when you come to court in a public law matter particularly, a lower court is required to decide all of the points, because there's always the possibility, particularly in this case, but there's always the possibility of someone appealing. Could I give the court the reference to Spillhouse? It's Spillhouse, S-P-I-L-H-A-U-S, Spillhouse Property Holdings versus MTN. It's reported at 2019, volume 4 of the South African Law Reports, page 406, a decision of the Constitutional Court, and the paragraph is at paragraph 44. If the court would indulge me and allow me to read that paragraph, because it does explain why I need to continue. It says, with regard to remedy, MTN suggested that in the event of the court holding that the applicants have standing, the matter must be remitted to the SCA, because the court did not address the merits of the mandatory interdict. So what had happened in that matter is that there'd been a case, it had gone to the SCA held that it lacked standing, and it dismissed the case on that basis. The matter went to the Con Court, and the Con Court was then confronted with an SCA judgment that dealt only with standing, not with the merits. And the Con Court said the following. It said, the Supreme Court of Appeal itself has said that it is desirable, where possible, for a lower court to decide all issues raised in a matter before it. This applies equally to the Supreme Court of Appeal. This is more so where, as here, the final appeal court reverses its decision on the chosen limited point. This may impact on the fairness of an appeal hearing. Litigants are entitled to a decision on all issues raised, especially where they have the option of appealing further. The court to which an appeal lies also benefits from the reasoning on all issues. So while we say with respect that the noli prosequi certificate is dispositive of the case against Ms. Maughan, it is with respect my duty to deal with the remaining grounds, and with respect this court's duty to grapple with them too, because that is what the Con Court has told us in Spillhouse.
I must understand from the judgment that it's only in the event that you concede that your submissions may be incorrect.
Well, no. I think with respect the difficulty is that at the stage in the lower court, one doesn't know whether they might be incorrect. So in that case,
No, we will. Once we have the judgment.
Yes, but if you were to uphold me on the noli prosequi point, as I submit that you ought to, there remains the notional possibility that the appellate court might disagree. And that is what happened because of course what happened in that case was that the SCA upheld a lack of standing. Everybody thought, the SCA and the party raising it no doubt thought they were correct. And the Con Court very politely but emphatically criticized the SCA and said you should have decided all of the points because you don't know what might happen later. And so, although I submit in this case it is largely theoretical because the noli prosequi point is so unanswerable, I submit with respect that it is necessary to decide the rest as well. Thank you, my lord. Could I then turn to deal on that basis with the second ground, and the second ground is abuse of process. Now, if I could begin with the principles, and I can do so briefly in light of the work that counsel for Mr. Downer has undertaken. The abuse of process point begins in our heads of argument at page 13, paragraph 30, and we deal with the principles there. And we make the point that the courts have long recognized their inherent power and indeed duty to prevent an abuse of process in order to protect the administration of justice. We've referred you to Phillips versus Buerta and the various cases on point. But for present purposes, I wish only to make 2 points. And the first, I accept, repeats my learned friend for Mr. Downer's submissions, but it's necessary because it's critical. The first question is motive relevant? Mr. Zuma says no, expressly. He says that even if this is a prosecution brought with a bad motive and for a bad purpose, that is irrelevant. With respect, that is wrong. It is wrong as a matter of law, and it's wrong as a matter of law in light of mineral sands at paragraphs 94 to 95, which is the latest pronouncement on point, and it is the unanimous judgment of the Constitutional Court, and it considered in doing so the judgment of Mr. Justice Hurrams in the NDPP case on which such heavy reliance is placed. So is motive relevant? Unquestionably, and I'll come back to mineral sands in a moment. But the second question which I must focus on is, are the merits of the prosecution relevant? In other words, does one just look at it by looking only at the motive, or is one permitted as a court to look also at the merits of the prosecution? Now, Mr. Zuma doesn't express a firm view on this, but it seems that his stance is no, because that's the only way of explaining why the attitude taken in the answering affidavit and in the heads is to kick everything to the trial. So the approach seems to be this court is barred from looking at the merits. It must kick everything to the trial in due course. If that is the proposition, then 2 points. Firstly, there is no authority cited for that proposition at all. And secondly, that proposition is plainly wrong as a matter of law. And could I demonstrate that to you with reference to 2 cases? The first is the Van Deventer versus Reichenberg case. It's the decision of the Cape Provincial Division in 1996. We've cited it at footnote 25. My lord, my ladies, we have prepared a bundle of authorities not to take you to during the hearing, but just if it would be of assistance. Could I beg leave to hand it up if it would be of assistance? My lord, it's only if you want it, otherwise I'll send it back to my attorneys with delight. Thank you. I haven't done a copy, Dali, because we're not referring to it. It's just the cases in the heads. Okay. So, my lords, and I won't take you to the bundle. The court can put the bundle away, but if I could just give you the reference. It's Van Deventer versus Reichenberg at paragraph 120, I beg your pardon, at page 126H to 127C. That is the same reference as in our footnote 25. And what it does in that case is, in the process of considering an abusive process, it expressly considers what it calls the prospects of success, by which it means the prospects of success in the prosecution. And it says it is a matter that bears no prospects of success, and it uses that to conclude that it is an abusive process and falls to be set aside. That would be good enough, but that has now been put beyond all doubt by the Mineral Sands Resources judgment. And could I just spend a moment telling the court what Mineral Sands Resources was about? I appreciate the court has read it, but the context may be helpful. What happened in Mineral Sands Resources, and both counsel for Mr. Downer and myself were in the case, is it was a defamation case. And the defamation case was brought, and the defendants amended their pleas to raise a special plea saying it's an abusive process, a slap defense, an abusive process. And they said it was an abusive process because the plaintiffs never had any hope of recovering money from them. They were journalists and community workers, and that the plaintiffs were just doing it to silence them. That was the plea. And the special plea made no reference to the merits. It said it's abusive because this is their purpose and this is why they're doing it, etc. And the plaintiffs took an exception to the special plea. And they said, firstly, our law doesn't recognize this kind of slap defense. But secondly, even if it does, you can never have a slap defense without considering the merits. And so the very issue that was before the Constitutional Court in Mineral Sands Resources is, when you are dealing with abusive process, do you have regard to the merits? And the court held unanimously and emphatically that you do. In fact, it upheld the exception on that very point, because it said that when we pleaded our special plea, we hadn't pleaded that the merits were weak, and that rendered the special plea excipiable. So the very point of Mineral Sands Resources is that abusive process requires you to look at 2 things. The motive, and Mr. Downer's counsel took you to that passage, the motive and the merits. And so Mineral Sands Resources has now established in our law that abusive process is something that can be dealt with by means of a special plea, or can be dealt with, in this case, as by means of the application, but it has to be both. You have to look at both the merits and the motive. So insofar as our learned friends for Mr. Zuma say you can't look at the motive, they are plainly wrong. And insofar as they suggest you can't look at the merits and you are required to kick it to trial, they are plainly wrong too. Now, against that backdrop, can we turn to deal with what we say are the series of grounds which demonstrate that this is an abusive process? I will deal with them in the same order that they are in the heads, but I will do so relatively briefly, mindful of the points that have been made by His Lordship presiding. So the first point we make, which we deal with at paragraphs 36 to 41, is we deal with the personal animosity of Mr. Zuma towards Ms. Maughan. Let me say before I deal with this, my lord and my ladies, we don't say that any of these stands by itself. We accept that abusive process requires the court to look at the case as a whole, including all of these factors. But instead of just running them all together, it's helpful to deal with them one at a time. We make the point at paragraphs 36 to paragraph 41 that Mr. Zuma has developed and demonstrated an extraordinary animosity to Ms. Maughan as a consequence of her reporting on his matters. Now, you will have seen from Ms. Maughan's affidavit that she is a journalist with an extraordinary history of reporting on the leading matters in our country over the past 20 years in the courts. Everything ranging from the VBS saga to the Celebi matter, to matters that have nothing to do with Mr. Zuma. But of course, because Mr. Zuma's matters have been so frequent and so prominent, she has also reported on many of his matters. And the allegations are made that he has developed a hostility towards her. That's the allegation in the founding affidavit. Now, what you see from the answering affidavit is utter confirmation of that hostility. And you see that in the passages we have quoted in paragraph 40. Because Mr. Zuma accuses Ms. Maughan, my client, of colluding, conspiring, and being in a partnership with state prosecutors to perpetuate a false narrative about his conduct and delays. In other words, he rejects the notion that she is a serious journalist doing her job. He says she is perpetuating a false narrative. And she then goes on to say, at paragraph 28, as is seen in this application, her decade-long reporting on this case has been to advance the state's misconceived views that I employed delaying tactics to avoid my criminal trial, that the view that she falsely and consistently perpetrates is that I faked my medical condition as part and parcel of stratagem of delaying my criminal trial, etc., etc. The accused applicant happily and uncritically hosts these views. And then she says, he carries on, and he then says in the last paragraph, ironically, and now that the shoe is on the other foot, Ms. Maughan is employing exactly the same weapons or strategy that she has consistently labeled as Stalingrad. In my view, this is nothing but duplicity and disingenuity laced with a touch of racist bigotry. Now, that is an extraordinary statement under oath about any opposing litigant. But if you needed any confirmation about what Mr. Zuma's views are of my client, he tells you. He says she is a racist bigot. Now, of course, we say that's patently not true, but those are his views. And the question the court will ask is this prosecution being brought out of a legitimate, dispassionate thought that a crime has been committed? Or is the prosecution being brought, at least in part, because he regards her as duplicitous, disingenuous, and a racist bigot? Well, we submit that the answer with respect is obvious. And you see it over the page where Mr. Zuma describes Ms. Maughan as being the propaganda machine of the media, a tool used by the NPA to perpetuate falsehoods, a hostile journalist who is incapable of balanced reporting, and an anti-Zuma crusader. With respect, is there a hostile attitude displayed, a personally hostile attitude displayed by Mr. Zuma towards Ms. Maughan? Unquestionably there is. So that takes us to the second point, which is if I say, and I submit, and I do, that this is not a genuine attempt to vindicate the rule of law by prosecuting a crime that has been committed, what is the purpose? What is the true purpose of this prosecution? And we address that true purpose in paragraphs 42 to 44 of the heads of argument. And we submit, and this is the case made out in the papers, because we have limited ourselves to the papers, that Mr. Zuma's summons is an attempt to discredit Ms. Maughan, to silence her, and to prevent her from reporting on the progress of his criminal trial. Now, to put that in context, what the papers demonstrate is that Ms. Maughan says that, as far as I am aware, I am the only journalist who reported on the initial trial who is still reporting on what is going on now. That's not denied. So the only person who has the full history is Ms. Maughan. And Mr. Zuma seeks to discredit her and prevent her from doing her job. He seeks to intimidate and harass her. And that is the purpose of this private prosecution. Now, how do we know that? We know that because Mr. Manyi, who is the spokesperson for the Zuma Foundation, made it clear before the charge sheet even landed. Because on 29 July 2022, and I'm now at 44.1 of the heads, Mr. Manyi posted a tweet on Twitter, which read as follows: "But Karyn, you are an implicated party in the matters of Downer. As a co-accused that has given a statement to the police, you shouldn't be involved in the story, surely." And that tweet was posted in response to an article that Ms. Maughan wrote on Judge Kun's judgment on Mr. Zuma's special plea. So Judge Kun delivers a judgment which rejects the special plea. Ms. Maughan reports on it, and she is met with a tweet from the spokesperson of the Zuma Foundation saying, "You are an implicated party in the matters of Downer, and as a co-accused," she's not, of course, a co-accused, but as a co-accused that has given a statement to the police, you shouldn't be involved in this story, surely. It is patently obvious what's going on. Just as Mr. Zuma hopes that his prosecution of Mr. Downer will end up in Mr. Downer being removed as the prosecutor, or in delay, he hopes that his prosecution of Ms. Maughan will prevent her from reporting on the story. And you can test the question by answering it this way. What is Ms. Maughan alleged to have done? Let's suspend disbelief, and let's assume that she has done what is alleged. What she did was to receive documents, allegedly, from Mr. Downer. Now we know that's not true, and we'll come to it, but just leave that aside. Why was their decision taken to prosecute Ms. Maughan? She was not the person who leaked the documents. She's not the person who is subject to Section 41 of the NPA Act. She's not the person who committed the wrong. And it would have been perfectly permissible, this is not civil litigation where you can take a plea of non-joinder, it would have been perfectly permissible to prosecute only Mr. Downer. But Ms. Maughan was lumped in. Why was she lumped in? She was lumped in because of two things. Because of Mr. Zuma's personal animosity towards her, the racist bigot that he views her as, and because he hoped to silence her and discredit her and prevent her from reporting. He no doubt hoped that what News 24 would do was pull her off reporting of the case on the basis that this somehow tainted her. Now, with respect, that is the reason she was lumped in. And it was clearly an afterthought. How do we know it was an afterthought? Because, as I've already demonstrated to you, when the initial complaint was made, there was no reference to Ms. Maughan. When the initial press conference was made, there was no reference to Ms. Maughan. But someone later had the brilliant idea that we'll add Ms. Maughan in and get two for the price of one and discredit her and silence her. Now, prior to Mineral Sands Resources, I could possibly have stopped there because the ulterior purpose and the ulterior motive is obvious. But let me go further, because just as in Reichenberg, what makes absolutely clear the abusive process is when you look at how utterly baseless the charges are. And we address this in the heads of argument from paragraphs 45 through to 52. We start at 45 to 46 by recounting what the charges are, and then we deal with the facts from paragraph 47 onwards. Before I get to the facts, let me say, the facts that I'm going to recount to you are common cause on these papers. They are common cause. They can be accepted. But what I would like to do is, instead of reading them to you in the order which we've put them, which for some reason didn't follow the chronology, and I take full responsibility for that, I want to give them to you in chronological order, because it makes absolutely clear how baseless these charges are. So I'm reading the subparagraphs from 47.1 onwards, but I wish to do so in chronological order. So could I begin with the... could I begin as follows? Give me one moment. So the first event is the one we deal with at 47.7, and all the references are there, but let me just summarize. We begin on the 9th of August. It's the 9th of August. It is 11:46 a.m. And at 11:46 a.m., Mr. Breitenbach, I beg your pardon, Mr. Downer's unsigned affidavit and annexures, which includes the Ulterior letter, is sent to Judge Kuhn. The court will see the actual, I'm not going to take the court to many places in the record, but I would take the court to 2 places. Could I ask the court to go to page 462 of the record? It is in volume 3, page 462. And it's, of course, in the Maughan papers, I should say. I appreciate the court is trying to deal with 2 sets. Thank you. At page 462, you see there an email from Billy Downer to Ms. Griffin, who was the clerk for Ms. Kuhn. And it says, "Dear Ms. Griffin, I indicated in my email I would send my affidavit once it is made. Due to the public holiday and the fact that my office is closed for decontamination and the urgency, I attach unsigned and uncommissioned affidavits by me and Mr. Advocate Nike for the attention of Mr. Justice Kuhn. And as soon as we've had them commissioned tomorrow, we will file them at court. And you will see there that CC are the attorneys for Mr. Zuma." So at 462, you see 11:46 a.m. on the 9th of August, the affidavit is sent for the attention of Mr. Justice Kuhn. And the court doesn't need to look, but if you go on 10 pages, 472, you will see that one of the annexures to that affidavit is the infamous letter, the medical letter that is at issue in these proceedings. So the start of the chronology is that on the 9th of August at 11:46 a.m., the application is sent to Judge Kuhn via email, copied to all the legal representatives, and it is common cause on these papers, it is common cause, it's pleaded in common cause that documents, particularly since the COVID era, have begun to be filed via email, particularly in this matter. I'll give the court a reference, you don't need to go there. It's volume 1, page 28, paragraph 45.3. So, the affidavit, complete with the medical letter, is sent at 11:46 on Monday, 9 August. The next event is that on the same day, a number of hours later, at 16:43, Ms. Maughan requests Mr. Breitenbach, not Mr. Downer, Mr. Breitenbach, to provide her with copies of the court papers that had been or would be filed for the hearing scheduled the following day. So that's some hours later at 16:43. And 3 minutes later at 16:46, Mr. Breitenbach sends Ms. Maughan the unsigned copy of Mr. Downer's affidavit together with the annexures, including the letter. So the affidavit gets filed in the morning. Ms. Maughan requests it at 16:43 that afternoon. Mr. Downer sends it at 16:46. Now, at the moment that Mr. Downer sent it, Mr. Breitenbach, the moment that Mr. Breitenbach sends it, that document was already a court document. It had already been filed because that's what Sanral tells us, and we've cited Sanral for you, and no contrary authority has been put up. So the suggestion that somehow Ms. Maughan received a document that was private is plainly bad, because the document had already been sent to Mr. Justice Kuhn, it had already been sent to the other parties. So that's at 4:46 on the 9th of August. Later that evening, just after 9 p.m., the same day, the 9th of August, Mr. Zuma's own attorney, Mr. Tusini, emails Judge Kuhn's registrar Mr. Zuma's signed postponement application, which also includes the letter. This is the second reference I would ask the court to go to, and the court will find this one in the same volume at 477. Does the court have it? Thank you. At 477, you'll see 9:07 p.m. Mr. Tusini is emailing the document. Herewith first accused notice of application for condonation, affidavit and annexures. And then if the court goes further, the court will see that the same letter is contained therein. Again, the court doesn't need to look, but it's at 487 10 pages thereafter. So by 9 p.m. on the 9th of August, the letter, the infamous letter, has already been filed twice. It's filed in the morning by Mr. Downer. It's filed in the evening by Mr. Tusini, this time attached to a signed affidavit. And then it's then filed again the next morning via the state's signed affidavits, and this is again done via email to the judge's registrar and the other parties, and that takes place at 7:33 in the morning on 10 August 2021. So by 7:33 on the 10th of August, the letter has been filed 3 times. Twice by Mr. Downer, once by Mr. Tusini, and no one has claimed any confidentiality over it. No one, including Mr. Tusini, has said this is confidential and may not be disclosed. No one has brought an order under the Superior Courts Act asking that it be barred. No one, including Mr. Tusini, Mr. Zuma's lawyers. And the first time that Ms. Maughan, in the words of the indictment, disclosed to News 24 readers and the general public the contents of that letter was when her article is published at 9:14 on the 10th of August. So by the time she discloses it to the public, which is the charge she is alleged to have committed, that letter has been filed in court 3 times. And we know what Sanral says, and no one doubts it, and no one, Mr. Zuma's counsel certainly do not suggest it's wrong, nor could they, and they do not explain how in light of that judgment, there could seriously be contended that there is a crime. Their only answer, and I need to spend a moment on it, their only answer is paragraph 60 of their heads of argument. Because, and I hope this is the correct version that the court has, but let's see. I have it as paragraph 60 of their heads on page 21, which begins what the applicants Downer and Maughan have expediently omitted. We're on the same page, thank you. What they say is that what the applicants have expediently omitted to mention is that the sharing of court papers with her did not happen in a vacuum or in the ordinary course of a journalist seeking information, but happened in the context of an existing relationship of engagements between Maughan and members of the prosecution team. I don't, with respect, understand the submission. Either the sharing of this affidavit was a crime, or it was not. Either the publication of the letter was a crime, or it was not. The fact that there may have been a history of engagements or otherwise is not relevant to whether there was a crime. Either Section 41 of the Act was breached, or it wasn't. This is, as far as I can find out, the only reference, the only attempt to explain why there might be a case against Ms. Maughan. And it is, with respect, hopeless. It then follows in paragraph 61, the point that was read by counsel for Mr. Downer about the leaks and justice come pepe. Of course, that is equally irrelevant to Ms. Maughan. There's no suggestion that she was the recipient of leaks. Even if she was, I mean, what are we doing now? Similar fact evidence? I just, with respect. That is the only passage I can find in the heads which seeks to answer whether a crime was committed. And it doesn't answer. So we are dealing with a case just like in Reichenberg that is utterly without merit. So what you have is a case brought by someone with a plain personal animosity to Ms. Maughan, brought for the purpose of silencing and intimidating her, and on charges that are utterly baseless. What more do you need with respect for an abusive process? The answer is nothing. There are 2 last issues which I will deal with, but I will deal with relatively briefly. And the first is Mr. Zuma's attempt to mislead this court about Ms. Maughan, and the second is the right to freedom of expression. We deal with the attempt to mislead the court in paragraphs 53 to 56. And it really is quite extraordinary what's happened here. In the answering affidavit, Mr. Zuma stridently alleges that Ms. Maughan disingenuously deleted tweets of 9 August 2021 in which Ms. Maughan had reported about the ill-gotten medical information. And he says under oath, this is a clear sign of a guilty and criminal mind in the form of knowledge of unlawfulness. And he then attaches an annexure JZD7. Now, I don't want to waste the court's time by going there, because JZD7 just doesn't indicate that at all. and that is painstakingly explained by Ms. Maughan in her replying affidavit. And what she explains in her replying affidavit, and if the court would just make a note, I won't detain the court, but if you just highlight that footnote 55, paragraphs 14 to 15 of the reply at 452 to 456. What Ms. Maughan explains is as follows. She explains firstly that she hasn't deleted either of the tweets that revealed the purported confidential medical information. She says that on oath, and she attaches from her Twitter feed the tweets that did so. So the suggestion that she's deleted them and it's a guilty mind is patently wrong. And then what she does is she lays out in considerable detail what has actually happened. And what it is that Mr. Zuma's attorneys have taken a screen grab of tweets. And there is a reference there saying this tweet has been deleted by the tweet author. But the tweet author was not Ms. Maughan. And what is explained is that the person who deleted the tweet was someone called @SheWas15. It's a tweet by someone. Nobody knows who it is. @SheWas15. And it was a tweet which didn't even seem to be directly relevant to this case. It said at age 8, and there was a whole series of responses. For any of the judges who've ever had the misfortune of being on Twitter, you will know that Twitter is not an organized conversation, and that people raise all sorts of bizarre things in response to different tweets. That doesn't matter for present purposes, except to say this. The tweet which was deleted was not by Ms. Maughan, and it did not contain the medical information which was said to have been leaked or disclosed. And when this point is made in answer, it is said in reply, paragraph 15, for the above reasons, Mr. Zuma's statement in paragraph 166 of his affidavit that it has since emerged that she disingenuously deleted her tweets of 9 August 2021 is patently false. The manner in which the evidence has been presented in JZD7 appears to have been a deliberate attempt to manufacture evidence against me and to mislead the court. Now, Justices, we all make mistakes. Affidavits are put up which say incorrect things. Annexes are put up on the basis of misinterpretation. But the one thing you would have expected is that when this affidavit was filed last year, there would have been a response which said, I accept that that is not the case, and I apologize to Ms. Maughan. There's been nothing. There hasn't been a denial of the allegation that it's a deliberate attempt to manufacture evidence against me and to mislead the court. There hasn't been an explanation as to what happened. There hasn't been a retraction, and there hasn't been an apology. And that is despite the fact that Mr. Zuma has filed 2 different affidavits since that affidavit came in. Now, the court will be aware of the judgment in Competition Commissioner Commissioner, which dealt with the fact that where serious allegations are made in reply, it is appropriate for the party against whom they are made to seek, and if they are false, it is appropriate for the party against whom they are made to seek the leave of the court to file a further affidavit. Here we've had 2 affidavits. Neither of them deals with it. And I'm afraid that on Plascon Evans and the ordinary rules, this court has no option. It must accept that this was a deliberate attempt to manufacture evidence against Ms. Maughan and to mislead the court. And if that is not the case, there ought to have been an affidavit saying it. This point about misleading the courts was in our heads last time. That's correct, isn't it? It was in our heads last time when the matter was called. It was in our heads this time. And there is no response whatsoever. So the court is faced with a potential private prosecutor who has an animus against Ms. Maughan, who has a purpose in trying to silence her, who brings a charge which has no merit, patently no merit, and who has now tried to mislead the court in the very case where this issue is raised. This is the clearest case for setting aside a summons as abusive process one could ever imagine. It makes Reichenberg look like a laughingstock. That means that technically the court doesn't need to worry about the last point, which is the freedom of expression challenge, because the evidence has stacked up so high that you don't need to worry. But let me deal with it briefly for the sake of completeness. Because we do say that there is a difference when the private prosecution is brought in an attempt to silence a journalist who is doing her job. Let me make clear, my lord and my ladies, what our case is and what our case is not. We do not say And the Amicus appears to be under a misapprehension in this regard. That's the Amicus, Democracy in Action. We do not say that a journalist has an absolute defense against a private prosecution. Of course we don't. We do not say that a journalist is entitled to break the law willy-nilly. Of course not. But what we do say is that where a member of the public, I'll come to a former president in a moment, but where a member of the public seeks to use a private prosecution to silence a journalist who is exercising her Section 16 right, that is an extraordinarily serious matter and one that weighs in the balance and inclines a court to conclude that there is an abusive process. There is, with respect, a difference, because Ms. Maughan is trying to exercise her Section 16 rights to freedom of expression, not for her own sake, but for the sake of the public. Why do I say that? Because that is what the courts have said again and again. That Section 16 is not about the journalists, it's not about the media, it's about the public who receive the information. And when someone brings a private prosecution gratuitously, because it could have been brought without citing her, gratuitously, in an attempt to silence and intimidate and discredit a journalist, that is an extraordinarily serious matter. Now, my lord and my ladies, it would be a serious matter if it was a case brought by Stephen Budlander. But the fact that it is a case brought by the former president who swore an oath to uphold the Constitution is an even more serious matter. And we submit that if there were any doubt, and there is no doubt, but if there were any doubt, that would emphatically demonstrate that this is an abusive process. So we submit that the charge against Ms. Maughan is patently flawed on all of those bases. It is an abusive process, and even if there were a certificate noli prosequi, and whether or not there is, it falls to be dismissed, set aside on that basis. That leaves the very last point, the third one, and that's Mr. Zuma's lack of standing to prosecute. I will not belabor the point. I will simply make the point that, as the heads demonstrate, what Section 7(1)(a) of the Criminal Procedure Act requires is that a person must prove some substantial and peculiar interest in the issue of the trial arising out of some injury which he individually suffered in consequence of the commission of the offence. Now, my lord and my ladies, you are no doubt all too familiar with the broad standing provisions of our Constitution. We are used to saying, well, pretty much anyone's got standing, and so we don't worry about it too much. Well, in this case, we do have to worry about it, because Section 7 says expressly that you have to prove some substantial and peculiar interest in the issue of the trial arising out of some injury which you've suffered. And in this case, it just hasn't been done. You look at that letter, you look at what was disclosed, you look at the circumstances, and there is no injury. No injury. So we submit that, and we make the point that, as Justice Kuhn found, the letter was not intended to be confidential, nor was it in fact confidential, nor did Mr. Zuma's attorneys treat it as confidential when it was filed. So it is difficult to understand how it can seriously be contended that the substantial injury requirement is met. For those reasons, Justices, we seek a similar order to Mr. Downer. We seek both an order setting aside the summons and the interdict, because otherwise we know what happens. The case gets brought again and again, and we would ask for those prayers. We would also ask for costs on an attorney-client scale. I say again, anybody can make a mistake, and perhaps to give them the benefit of the doubt, let's assume somehow that Mr. Zuma and his legal advice on the criminal case, once Ms. Maughan's affidavit landed, they knew they had no case against her, both because of what's in her affidavit and because of what's in Mr. Downer's papers. But they have resolutely insisted on prosecuting Mr. Downer and Ms. Maughan in these circumstances, where it was patently obvious from months ago, at best for them, that there was nothing in it. This is a case where attorney and own client costs are justified, including the costs of due counsel, and we would ask for that costs award. Is there anything else? My lord and my ladies, those are our submissions.
Thank you.
Thank you, my lord.
I think that is me, my lord, the Amicus Helen Swisman Foundation, who appears in the Downer matter.
And your name again, please?
Kate Hoffmeyer. Thank you. My lord and my ladies, this matter implicates the rule of law. And it is because it implicates the rule of law that the Helen Suzman Foundation sought and was admitted as an amicus curiae in the Downer interlocutory application. My lord and my ladies, it did so to advance two main submissions. And you will have seen from our heads of argument that it is those two submissions that we advance and to which I propose to confine our oral argument today. But not to do so in a way that's repetitive, but rather to highlight the essential points that we wish to emphasize today, and also to be responsive to the heads of argument that we've received from Mr. Zuma subsequent to filing our heads of argument. My lord and my ladies, those two arguments are the following. The first is that it is evident from Mr. Zuma's own documents and his own conduct in prosecuting this private prosecution that he does so for an ulterior purpose. So let me just frame, if I may, where that argument fits. You've already heard from my learned friend Mr. Budlander from Mr. Downer this morning that Mr. Downer himself says that this prosecution should be stopped because it is pursued with an ulterior purpose. The Helen Suzman Foundation says that that is so similarly, but does so on a different basis to the basis that Mr. Downer advances. Mr. Downer advances that case based principally on considerations of delay, considerations of the impact on him as a prosecutor, given the unique circumstances of this case. But what the Helen Suzman Foundation says is you can take Mr. Zuma's conduct on its own with nothing more. Look carefully at the substantial statement of facts that he put up together with the charge sheet. Take a look at the list of witnesses that he prepared, and then look at his subsequent conduct in putting his docket together. And all of that, we say, conduct by Mr. Zuma himself, indicates that this case is pursued for ulterior purposes. My lord and my ladies, the second aspect on which the Helen Suzman Foundation was admitted as an amicus was to explain the extent to which granting the relief sought by Mr. Downer will protect prosecutorial independence in the administration of justice. And on that aspect too, we make different submissions to those of Mr. Downer. So if I may commence with the first of those, and my lord and my ladies, you'll pick that up in our heads of argument from page 4 under the heading Ulterior Purpose. Thank you, my lord. My lord and my ladies, we begin with the law, and I actually would like to spend a bit of time on the law because there is a respect in which Mr. Zuma's response to this case is fundamentally misconceived as a matter of law. My learned friend Mr. Budlander for Mr. Downer already took you through that. He took you through His Lordship Mr. Justice Hurrem's statement in the 2009 Zuma case, on which great reliance is placed by his counsel in this matter, but went on to show you that you can't stop reading where Mr. Zuma's lawyers end, because the statement immediately after, the statement that says a bad motive can't turn a good prosecution, or in that case an arrest, into a bad one, and conversely so, is followed by the statement that that does not mean exercises of power for ulterior purposes does not implicate the principle of legality. They do. And the reason why that is so is because our law, and we say this at paragraph 6 of our heads of argument, has recognized that powers are conferred for particular purposes, and that when a power is used for a purpose not authorized by the law, the principle of legality is undermined. So this is a case all about the proper use of powers. And what we set out in paragraph 7 is a series of illustrative examples that have come before the courts where the misuse of a power given for purpose A but used for purpose B, has resulted in the courts weighing in and interdicting further conduct by those who are abusing the power. So the first example is the example of a search and seizure situation. It's actually the case of Highstead that is referenced by Justice Hurrens in the 2009 decision involving Mr. Zuma. That's a case where search and seizure powers were used not to get evidence for trial, which would be a legitimate use of that power, but rather to put the subject of an investigation out of business. And the High Court said, well, when you use a power designed for a purpose, collecting evidence for a different purpose, to put the business out of business, they will grant an interdict against the further use of the search and seizure power. The second example is the infamous case involving sex workers that came before the courts in around 2009. There, the courts found that the police were using their power of arrest, albeit with a well-founded criminal case. Sex workers were plying their trade in circumstances where that was a criminal offence. But the facts showed that the police were doing so in order to intimidate, harass, and punish the sex workers, rather than to bring them to justice. The evidence showed they had no real intention of pursuing those prosecutions. They'd be arrested, they'd end up in the police cells, and then they'd be released thereafter. And in that circumstance, the courts weighed in, declared the conduct unlawful, and interdicted the police from engaging in arrests in similar circumstances. Over the page of paragraph 7.3 of our heads of argument, we talk about the case of another arrest case, where the professed purpose of the arrest was to bring a person before the court, but the court found that it was actually being used to frighten and harass the person arrested, to induce him to act in a way that the arrestor sought. And so our courts held that that arrest would be illegal. And even in wartime, where a power to seize articles was used not for the purpose of procuring evidence, but to advance the efforts of a food distribution scheme, the courts weighed in and held that the seizure was illegal and required the confiscated item, in that case it was rice, to be returned to the relevant accused person. And finally, at 7.5 is the case of Nedcorp, which I'd like to spend a bit more time on, with your leave, my lord and my ladies, because it actually has some essential principles for the purposes of this case. That was an interesting case. It was a case involving a bank which was alleged to have breached Section 10.4 of the Usury Act, which required it to make certain information and documents available when a client of the bank was making inquiries about the rates of interest that were being charged on certain facilities. And the Act made it an offence for a bank to fail to produce that information. So what happens is Nedcorp in that case gets approached for these documents and information and produces some, but not, let's take it as given, the full extent of what was required to be produced. And pursuant to that, a private prosecution is brought. It's brought by the respondent in that case, Gilitshana, but standing behind the private prosecutor was an individual, Kilik, who had a series of businesses that were plying the trade of assisting bank clients to recalculate the interest on their loans and thereby resist foreclosure. And what happens in the course of that case, if I may take my lord and my ladies to that case, I know that you will have looked at it, and so I'm just going to read one aspect of the pertinent paragraph. It comes at paragraph 27, if we can start there. What the court says there is ordinarily the reasons and motives of a party for instituting legal proceedings are irrelevant. However, when a court finds an attempt made to use for ulterior purposes machinery devised for the better administration of justice, it is the duty of the court to prevent such an abuse. It is a power which must be exercised with great caution and only in clear cases. And then over the internal citations. In Van Deventer, which was the case to which my learned friend for Ms. Maughan mentioned, the court held that it has a power to interdict a private prosecution which is irregular, vexatious, or an abusive process. The power derives from the inherent jurisdiction of our superior courts to prevent an abuse of their processes. Yes, my lord.
Brought to my attention that there's a gentleman there who seems to be taking photographs. In case you were not chair before the matter commenced, we specifically prohibited anyone from taking photographs whilst court is in session. We ask you to kindly respect that decision. Thank you. Sorry.
No.
That's all.
My lord and my ladies, I was simply reading to you from paragraph 27 of the Ned Court decision. It's a further articulation of the proposition that when powers designed for one purpose are used for another, that will constitute an abuse of the process of the courts. And the judge goes on, it's Justice Erasmus in that case, at the end of paragraph 27, to say that although such power will be exercised with caution and only in a clear case, the courts will not hesitate to act when necessary, lest the administration of justice attracts disrepute. My lord and my ladies, this case we submit is important for another reason, because you've heard my learned friends this morning talk about the relationship between motive and merits in a case of abusive process. NEDCOR is interesting, we submit, because it is a further example along that continuum of cases. And it says something slightly different to the cases you've been referred to this morning. In this case, the High Court assumed in favor of the private prosecutor that there was a good case on the merits. Not made a finding, but assumed in favor of the private prosecutor that there was a good case on the merits, and yet found that there was an ulterior purpose so employed that the prosecution should be set aside. And we offer that case to the court today simply to explain that there is a continuum. We will not traverse the grounds on which counsel for Mr. Downer has explained to you that there is no substantial case that Mr. Downer has to meet. In other words, the merits of this case are non-existent. But we go one further and say to you, even in a case where you were willing to assume in favor of the private prosecutor that there is some case, something to answer for by the accused, you can still, if you are satisfied that a power granted for a particular purpose, in this case the power of prosecution is a power to bring the accused person to justice, is being used for some ulterior purpose, you can quash that prosecution. And we say that Mr. Zuma's own conduct in this case should admit of only one answer to that question. This is a case pursued for ulterior purpose. And let me explain why we say that. My lord and my ladies, we pick this up at page 7 of our heads of argument, from paragraph 15. There's a heading there entitled Mr. Zuma's own conduct. My lord and my ladies, you will have seen in Mr. Zuma's heads of argument, in response to the Amicus, that, at least insofar as Helen Suzman Foundation is concerned, there's a repeated refrain that the Helen Suzman Foundation's arguments that this prosecution constitutes an abusive process is, quote, not supported by any evidence. They throw that out as a criticism of the argument of the Helen Suzman Foundation. Well, our answer to that is a simple one. The Helen Suzman Foundation did not present any further evidence because its entire argument is that you can take Mr. Zuma's own conduct as the indicator of the ulterior purpose. And that is for 3 reasons. We say you can look at the substantial statement of facts, you can look at the witness list, and you can look at the police docket. Not the police docket, his docket. that he's prepared for this private prosecution. And on a proper analysis of those 3 documents, the conclusion that this private prosecution is pursued for ulterior purpose, we say is unavoidable. Why is that so? Well, the charge that Mr. Downer faces is a simple one, in fairness. It's a breach of section 41(6) and 7 of the NPA Act. We know that it has to do with disclosures of information to 2 journalists, one in 2008, Mr. Soul, one in 2021, Ms. Maughan. And we know that the allegation is that that disclosure was done in breach of the requirements of the NPA Act. That's the charge. What does the statement of substantial facts say about the evidence that Mr. Zuma says bears on that charge? And for this, you will find we commence the discussion at page 10 of the heads of argument, from paragraph 23. Now, in paragraph 23, we reference the fact that the only allegation relevant to count 3, that's the count involving Mr. Soul, appears in 2 paragraphs of the summary of substantial facts. And they read as follows. Between the 4th and the 13th of June 2008, Mr. Downer engaged in numerous telephonic discussions with Mr. Soul, a journalist, for and on behalf of the Mail and Guardian, during which Mr. Downer disclosed information in relation to the self-same prosecution of Mr. Zuma, which had come to his attention during the course and scope of his performance of his duties and functions as a member of the NPA, without the authority of the National Director. And then the second paragraph, in this regard, Mr. Downer specifically divulged to Mr. Soul sensitive or confidential information acquired in his capacity as prosecutor without a written authorization of the National Director. Those are 2 paragraphs in the entire statement of substantial facts dealing with the charge involving Mr. Soul. And insofar as the charge against Ms. Maughan is concerned, we deal with that at paragraph 24, you have a set of paragraphs within the statement. They are paragraphs 38 to 48. The court has the references in our heads of argument. I won't take you there. The force of our point, however, is that the statement of substantial facts is much more than 12 paragraphs. The 2 devoted to Mr. Soul and the 10 devoted to Ms. Downer. The majority of the paragraphs of that statement do not deal with facts relevant to the charges at all. Instead, they traverse the background leading up to Mr. Zuma's first indictment on charges of corruption and to the decision not to prosecute him. These paragraphs constitute the bulk of the statement. They are paragraphs 10 to 23 and 26 to 37. Now, the question of whether Mr. Zuma was previously correctly indicted, the question whether his prosecution was pursued for a political purpose or not, the question whether the decision to prosecute him was correctly or incorrectly made, have been traversed through our courts for the better part of the last 2 decades. They are wholly and completely irrelevant to the charges he brings against Mr. Downer. Let's move on to the witness list. The witness list is important because Mr. Zuma concludes his statement of substantial facts with the following proposition. He says he intends to call the witnesses indicated in the attached witness list in support of his case. That is Mr. Zuma's own words. He doesn't put up the witness list because these might be people that he's going to question and present as witnesses. He will present them as witnesses in the case he brings against Mr. Downer. And we deal with the witness list at page 12 of the heads of argument. What does the witness list tell us about the purpose with which this private prosecution is brought? Well, the first notable thing is that there are people identified in that witness list that are never even mentioned in the charges at all and are in no way linked to those charges. We identify 3 of them as, quote, the political figures. They include President Ramaphosa, Minister of Justice Ronald Lamola, and the Director General of the State Security Agency, Thembelisile Majola. There is absolutely no indication whatsoever as to what those witnesses have to do with the charges that have been brought against Mr. Downer. Not a mention. The statement doesn't link them at all to this private prosecution. The next category of witnesses are witnesses, we call them historical witnesses, old witnesses on political interference. They are witnesses that you can at least link to parts of the statement of substantial facts, but unfortunately it's to the sections of the statement of substantial facts that have nothing to do with these charges. It's the historical retreading of the argument about the terms on which Mr. Zuma was originally indicted, the political interference alleged in that decision making. They include, and we're at paragraph 36 of our heads of argument, Mr. William Andrew Hofmeyer, Mr. Mokatedi Mshe, and Mr. Lawrence Moshwana, the former public protector. At least in respect of those individuals, there is a reference to them in the statement of substantial facts. But beyond that, no relevance whatsoever to the charges that are being levelled at Mr. Downer. Now, my lord and my ladies, Mr. Zuma has an answer to this alleged irrelevance that permeates his statement of substantial facts and witness list. And if you go over the page in our heads of argument to paragraph 38, we endeavour to capture it. Because this is a serious allegation. This is an allegation made by Mr. Downer that his prosecution is being pursued for an ulterior purpose. And at a point in his founding papers, he says that the witness list is sensationalist and irrelevant. And what is Mr. Zuma's answer to that? Well, we capture it in paragraph 38 of our heads of argument. Mr. Zuma's response is that he denies that the witness list is sensationalist, and then he says the following: even the detail of witnesses listed therein has a contribution to make to the factual exposition of the offence. With all due respect, that is a vacuous statement. It says nothing whatever about the relevance of those witnesses. It says the witnesses are relevant because the witnesses are relevant. That is what it says. And there is no more. At a minimum, a prosecutor, a private prosecutor, genuinely intent on bringing Mr. Downer to justice, would have answered that allegation with care, would have said this witness is relevant to this aspect of the charge. This traversing in the statement of substantial facts is relevant to this aspect of the charge. But you search the answering affidavit in vain for any such explanation. And then that brings us to the most recent conduct of Mr. Zuma that we highlight at page 16 of the heads of argument. It's what can be gleaned from the prosecution docket that Mr. Zuma has prepared. My lord and my lady, these are facts that come from a further affidavit that Mr. Downer filed in February of this year. What that affidavit tells the court is that Mr. Downer has been provided by Mr. Zuma with a copy of the private prosecution docket, Mr. Zuma's private prosecution docket. He was given it on the 14th of February this year. Mr. Downer tells us the docket contains the statements on which Mr. Zuma says he will rely in the prosecution of Mr. Downer. But when you open that docket, as Mr. Downer did, he saw that the docket contains no more than the statements that were already in the police docket when they originally looked at this matter. And this is the point of significance. You're told by Mr. Downer it contains no statements by any of Mr. Zuma's proposed witnesses from the witness list. And in the absence of witness statements, Mr. Downer makes the trite point that Mr. Zuma can't possibly and permissibly call the witnesses on his witness list. And that drives Mr. Downer to conclude that Mr. Zuma has no intention of calling the witnesses on his witness list. My lord and my ladies, what does that mean? It means the documents with which Mr. Zuma commenced this private prosecution are documents on their face revealing his ulterior purpose. Statement of substantial facts traversing matters wholly unrelated to the charges. Witnesses included with no link to the charges, but to resuscitate arguments 20 years old about the process of prosecution against Mr. Zuma. And then the most recent step, not even a docket that includes witnesses, statements from the witnesses that Mr. Zuma says he's going to call at the criminal trial. My lord and my ladies, we say that that conduct, Mr. Zuma's own conduct, is evidence sufficient to conclude that this prosecution is pursued for ulterior purpose, whatever you make of the merits. But you've heard my learned friend, Mr. Budlander, about why there is no case on the merits. There are two responses from Mr. Zuma to this argument. The first is that Mr. Zuma says you shouldn't stop a prosecution before the trial because there are protections after the trial. Those are the protections in the Criminal Procedure Act that allow, in circumstances where the process is found to be vexatious or unfounded at the end of the trial, the accused person can get costs and expenses back from the private prosecutor. But my lord and my ladies, we say that that's no answer, because the violence done to the rule of law by a private prosecution pursued for ulterior purpose cannot be cured by costs at the end of that trial. The only proper response to it is to interdict those proceedings now, before they proceed. The second answer from Mr. Zuma appears at paragraph 130 of his heads of argument in response to the Amicus. Mr. Zuma complains that what the Helen Suzman Foundation is doing is trying to dictate to him how he must plead and present his case. We say that is not Helen Suzman Foundation's position at all. In fact, we take no issue with the way in which Mr. Zuma has presented his case. That's his choice. But we say you can glean certain undeniable conclusions from the way in which he chose to present that case. So we say that is not an answer to this point. My lords and my lady, that leaves me to the second and last aspect of our argument. I know that we're very close to the lunch adjournment. I don't imagine I'm going to be much more than 5 or so minutes. So with your leave, I propose that I complete the argument, alternatively can return after the lunch break to conclude it.
Just to watch you working
My watch or my calculation of time, my lord, but I'll certainly keep to the 5 minutes. My lord and my ladies, you've seen in the section on prosecutorial independence in our heads of argument that commences at page 18 that we spend some time traversing both the South African legal position and the international and comparative position on the importance of prosecutorial independence. The point we sought to emphasize in that analysis is the pivotal role that prosecutorial independence plays in the administration of justice. You will have seen the Constitution requires that national legislation be enacted to ensure the independence of the prosecutorial function. You will have seen that the National Prosecuting Act itself does two things. It provides that the prosecuting authority must perform its functions in good faith and without fear, favour or prejudice, but it also expressly places the concomitant duty on those who engage with the prosecution service. It says that no one may improperly interfere with, hinder or obstruct the prosecuting authority or any member thereof in the exercise, carrying out or performance of their powers, duties and functions. That principle is echoed in the international instruments to which we refer, and I'll pick up only one of those because it is representative of the position that's taken throughout the international instruments. That's at paragraph 58 on page 21 of our heads. And it's Article 4 of the United Nations Guidelines on the role of prosecutors. It says, states shall ensure that prosecutors are able to perform their professional functions without intimidation, hindrance, harassment, improper interference, or, and this is the part that we emphasize, unjust exposure to civil, penal, or other liability. Now, I must pause there. That statement of the principle has an important qualifier. It says that they should not be subjected to unjust exposure to civil, penal, or other liability. It is no part of Helen Suzman Foundation's argument before you today to say that there are never cases in which private prosecutions can be pursued against a member of the prosecution service. There must be circumstances in where that is appropriate, because otherwise the prosecution service would be above the law, and that is not a principle in accordance with the rule of law. But what it does say is that they must be justified instances. Unjust instances will implicate prosecutorial independence. And so the question that we say is before the court today is what to make of the particularly unique circumstances of this case. This is a case in which a criminal accused pursues a private prosecution against his own prosecutor while his criminal trial is pending. We indicated at page 25 of our heads of argument that in preparing our heads we looked as far and wide comparatively as we could to find an instance of a case where this had happened before. We cannot find one. We cannot find one where a criminal accused privately prosecutes his own prosecutor while that case is still pending. And we say that that unique set of circumstances will require this court to ask in the full conspectus of the facts of this case what it means. And our answer there is that when that unique set of facts is set together with the submissions that we've made already on ulterior purpose, the conclusion will be that this is an unjust interference with prosecutorial independence. It's an effort without justification to inhibit and interfere with the criminal process that must now, after 20 years, begin to run against Mr. Zuma. There are two answers to that from Mr. Zuma. I'll deal with them briefly. The first is that this prosecution doesn't threaten prosecutorial independence because Section 13 of the Criminal Procedure Act allows the National Prosecuting Authority to take over a prosecution when they deem it necessary to do so. But we say Section 13 is no answer to this case. If the submissions of the Helen Suzman Foundation and Mr. Downer are correct, this is a prosecution that is an abuse of the process of the courts. That is not a prosecution that the NPA would ever take back over to itself under Section 13. And then the final answer from Mr. Zuma is that because it's been recognized in other contexts, they use the example of the General Counsel of the Bar taking disciplinary proceedings against former prosecutor Jiva, that because that instance can take place without prosecutorial independence being threatened, so too can this instance of a private prosecution against a prosecutor not impact prosecutorial independence. Our answer to that submission is it all depends on the facts. Of course there will be cases where going through disciplinary processes won't implicate prosecutorial independence. This is not such a case. This case, because of its peculiar facts and because of Mr. Zuma's own conduct, can resolutely be concluded to be an instance of a private prosecution that does threaten the independence of that authority. So, my lord and my ladies, the submissions of the Helen Suzman Foundation are in essence the twofold ones I've addressed to you today. That on the basis of Mr. Zuma's own conduct, the conclusion that this prosecution is pursued for ulterior purpose is inescapable. And secondly, that it would be important as a mark of upholding the administration of justice and prosecutorial independence, which is an essential ingredient for it, that this court step in and prevent the abuse that lives at the heart of this prosecution. My lord and my ladies, there's a substantial portion of Mr. Zuma's heads of argument in response to the amici that traverse the argument for why the amici should not be admitted. We have not addressed that in our heads of argument filed before you, nor have I addressed them today, because we see them as entirely irrelevant. We were admitted. We were admitted pursuant to an order of this court on the 10th of March. Those are numerous allegations, often gratuitous accusations against the Helen Suzman Foundation, unfounded accusations, but most importantly, we say irrelevant. So it is not my intention to address them to you today. If my learned friends endeavour to go there, however, in their argument, I will beg an opportunity to deal with them in a short reply, because they cannot go unanswered, but our primary submission is in the light of the order admitting the Helen Suzman Foundation, they are irrelevant. So too, sorry, I've just been handed a note, I'm not certain what it means, but I'm sure it'll be clarified in due course. They conclude their heads of argument, these are the heads of argument for Mr. Zuma, with the following statement: that the submissions of the Helen Suzman Foundation should be dismissed with costs. Now, just that framing is interesting. You would dismiss the application for admission if you thought it was bad, certainly, but we've been admitted, so that's not on the table for today. If you find the submissions presented by the Helen Suzman Foundation to be wrong or unpersuasive, then you will say that, but you don't dismiss the arguments. The arguments are just those. They're made for you today pursuant to a court order. And the with costs does not make sense to us either, because the law on costs in relation to amici is set out in the case of Hoffman. It's a constitutional court decision. If I may just give you the citation there, it appeared in our previous set of heads of argument. It's Hoffman versus South African Airways, 2001, 1 South African Law Reports, 1, the judgment of the Constitutional Court. And the point is simple: an amicus is neither entitled to nor liable for costs pursuant to its submissions in a case in which it's been admitted. And for that reason, my lord and my ladies, we don't address the aspects of admission, but with your leave, if they are traversed, we would beg an opportunity to address them in a short reply. Those are the submissions of the Helen Suzman Foundation.
Yeah, no, it's unbelievable, but they do this all the time.
It's the first time I've seen it.
No, but for now, they like it.
What I think is
But I mean, if they can't attack your arguments, then they attack you. But they're attacking both the arguments. So the variety of the big story of the time is almost narrated. Well, if you get British approach to discuss it, maybe there's no actually. Maybe it's just a phrase that needs to be done. But we've said Western. We've actually said, what is plea? We say his main, his obsession, as we say obsession, what it is equal to slave. It is a metaphor. He wants to write a book one day about how he proceeded to be. We say that. No, it's not every case. When you want to, there's a
Sorry, are you appealing for the own meeting? All three of you?
what harm to freedom of expression may result. And we submit that the private prosecution of Ms. Maughan ticks all of those boxes. We'd say the private prosecution of Ms. Maughan relates to the exercise of her right to freedom of expression in the public interest. The second is that the prosecution is brought with an ulterior purpose or motive, in intimidating and silencing Ms. Maughan, and depriving us of the opportunity to hear what she has to say. And the prosecution plainly lacks merits and prospects of success. Now, Mr. Zuma in his heads of argument contends that the Constitutional Court was careful not to extend the slap suit defence outside of defamation suits. As this court will know, the Mineral Sands judgment concerned a special plea. Those were the facts in which the defence had been raised. However, nothing in the court's judgment limits its reasoning either to defamation suits or to the defence being raised in the manner in which it had been raised in that case. As the court recognized, slap suits take a wide range of forms. Moreover, the court recognized that in discussing the nature of the suit, that it can take the form of a prosecution. At paragraph 42 of that judgment, I'll just ask you to take note of that reference, because there's a specific reference to prosecutions. It recognizes prosecutions as one of the types of proceedings that a slap suit can take the form of. We submit that there's no merit in that submission. I had intended to address this court on the question of relevance, but I think that that's been very ably handled already, and I don't intend to address those points. The next point to address is one that's raised by the respondents, to suggest that what we're attempting to do is to give the media a get out of jail free card or an easy out. The contention is that if these arguments are upheld, the media can act with impunity. Of course, that's not the case. And as Ms. Hoffmeyer for the Amicus Foundation has said in respect of prosecutors, should there be a plausible case in respect to which a member of the media has been charged, we don't suggest that case cannot be brought if it was meritorious. What we're highlighting is that journalists should enjoy protection from meritless and abusive litigation. And so any legitimate prosecution would never be hit by the slap suit defence. So there's really no concern raised in that regard. And it's never been anyone's argument that the media should never be, or are never in a position to be prosecuted, that they should enjoy any kind of immunity. There's also a contention that the slap suit defence cannot be raised vicariously, cannot be raised by the Amicus. We raised the slap suit defence under the authority in Mineral Sands even before the Concord judgment was handed out. We handed down. And we highlight it as a contextual factor for this court to be alive to in how it handles the question of how it arrests any abuse in this case. But in any event, what's important isn't who brings the complaint. Arresting an abusive process is the court's duty. And an abusive process is not one that's visited only on the applicants. It's abusive to the court and it's abusive to the public and to the rule of law. And that's who stands to suffer should the abuse not be arrested. There's also a suggestion that from my learned friends for Democracy in Action that such a defence could only be pursued in the clearest exceptional cases. And we said that there's no authority for that. What the Constitutional Court did recognise when referring to the authority in Phillips is that where one strikes out a prosecution for an ulterior purpose, great caution must be exercised and it must be in a clear case. But that's a separate type of. We're concerned. My submissions and the submissions of the Amicus concern a different type of abuse, so that's not applicable. But in any event, care and caution are not equivalent of exceptional circumstances. The courts haven't recognised that kind of threshold that needs to be met. There's also a suggestion, there's a strong argument, there's an argument that's made by the Democracy in Action as well, that a slap suit defence and the abuse of process arguments may only be raised in the criminal trial and not before the matter has proceeded to trial in the motion court, in the civil court, as it were. We'd suggest that there's no authority for that proposition, and it's misconceived because the harm, when one understands the harm that's sought to be arrested with a slap suit, is the harm in the prosecution. So it doesn't help if at the end of any prosecution of Ms. Maughan that the court says, and we also recognise that this was a slap suit, and she could have raised, and her defence that it is a slap suit should be upheld, because by then the court will have resolved the issue and she would have been acquitted. The harm is in the prosecution. The harm is in the suit, and that's what needs to be halted. And that's why it doesn't make sense to seek to do it during the course of a criminal trial. So, with submission, that's why an expeditious dismissal is required, and that's why the relief sought by the applicant itself is appropriate. And Mineral Sands didn't say anything to the contrary with submission. The reference to a trial in Mineral Sands on which reliance is placed is because in that matter it concerned a trial. That's the context in which it had been raised. The court doesn't say that's the only context in which it can be raised. Now, as to the question of whether this court is entitled to look into this matter, notwithstanding that it's a criminal matter and this is a civil court, one can readily think off the top of one's head of examples in which there are proceeding civil litigation which isn't involved in the actual the pursuant action. So, for example, one can consider in a summary judgment application, one's entitled to look into the merits of what's being raised. That court would do so on a preliminary basis. In a rescission application, the court's interested in knowing what's going to happen at the trial. That doesn't mean that the court hearing those applications is usurping any power of the subsequent court. The court is perfectly entitled to do that. And in a legality review, if one were to seek to set aside on a legality review basis a decision to institute a private prosecution, the civil court would do that, and it would do it before the prosecution would run. There's really nothing outlandish about this submission. And my learned friend Mr. Button has already pointed out that the decision of Ramaphosa has put to bed that submission in any event, and that's a full court decision. As to our second contextual factor, I'll move away from slap suits. Our second contextual factor relies again on a number of UN reports, and we say that the context that is important. It's important that this court has regard to that context, because the media Amicus submit that it's necessary to understand this full spectrum of attacks on journalists in order to understand this attack on this particular journalist. And I'll refer this court to just two of the authorities to which, or two of the international instruments to which we refer in our heads of argument, which have highlighted the specific attacks on women journalists. So the Joint Declaration on Freedom of Expression and Gender Justice, which was adopted in 2020, has highlighted and expressed deep concern that online gendered violence, gendered hate speech and disinformation, which cause serious psychological harm and can lead to physical violence, are proliferating with the aim of intimidating and silencing women. They condemn the online attacks and harassment of women journalists as one of the most serious contemporary threats to the safety of journalists and freedom of expression. And they recommend that states develop and implement integrated prevention, protection, monitoring, and response mechanisms to ensure the safety of women journalists. In 2021, the UN Special Rapporteur released a report which noted the pervasive form of gender censorship through the use of online sexual and gender-based violence, hate speech, and disinformation to silence women, and which emphasizes that attacks on women journalists violate not only their freedom of expression, but also society's right to information from diverse media. My lord and my ladies, there are further references in the heads of argument, which I won't belabor now. The point is that Ms. Maughan has already confirmed that such attacks have taken place against her, and that they are related to the private prosecution. And Mr. Zuma's private prosecution of Ms. Maughan, with its accompanying online intimidation, its threats, its harassment, must be considered in that light as a pattern of attack against women journalists intended to silence them and to drive them out of public participation. Such attacks undermine the creation of a safe and favourable working environment for women journalists, and it's imperative to have this context in mind when this court exercises its discretion. The third contextual factor, my lords and my ladies, relates to section 41.6 and its interpretation. Now, Ms. Maughan argues that in her application, that factually she did not breach 41.6. That's because at the time it was published, at the time that the contents of the letter were published, it had been annexed both to the signed and unsigned affidavits of the state, both of which were before the court. Now, Mr. Zuma's proposed interpretation, we say, is unconstitutional. We say it's a blunt interpretation. He says that the disclosure, the disclosure of any information, I'll read the section, it says, no person shall, without the permission of the director, national director, or a person authorized in writing, disclose to any person contents of any book or document or any other item in the possession of the prosecuting authority. Now, that section we submit, can't be contravened where the document to which reference is made is already a public document. And we know, with respect to submission, from all the tried authorities that we must adopt a constitutional interpretation of the section, and not the blunt one that Mr. Zuma advocates for. There is also a draft one which advances section 16 media right to freedom of expression. We submit that the one that's advanced by Mr. Zuma is offensive to both sections 16 of the Constitution and it's offensive to the open justice principle. Now that's a principle, my lord and my ladies, which is deeply rooted in our constitutional rights. The Constitutional Court in Shinga versus the State spoke about the open justice principle in criminal proceedings specifically. And it says, seeing justice done in court enhances public confidence in the criminal justice system and assists victims, the accused, and the broader community to accept the legitimacy of the process. Open courtrooms foster judicial excellence, thus rendering courts accountable and legitimate. Were criminal appeals to be dealt with behind closed doors, faith will be lost. Faith in the criminal justice system may be lost. Now, we submit that's the context in which Ms. Maughan made any disclosure of those, in which the disclosure was made, and in which the reporting took place. Open justice. This is reporting on criminal proceedings which are presently before the court and which are matters of public interest. That open justice principle is a key component of the rule of law. Now, this court's familiar, of course, with the Sanrail Authority, which says once a document's filed with court, it's a public document. This court will also be familiar with the authority in Savoy, which deals with that open justice principle. And there the court, majority decision, confirmed that the open court principle is deeply rooted in our procedural law, and as stated above, it's constitutionally entrenched. The Constitutional Court has confirmed that the default position is one of openness and disavows an approach that proceeds from a position of secrecy. And that's with submission the effect of the interpretation of section 41.6 as advanced by Mr. Zuma. And of course, we know that media freedom is advanced by the timeliest disclosure and timeliest reporting on newsworthy events. Now, my lord and my ladies, I've already addressed the fact that we've never intimated that the interpretation of section 41.6 that we advance is one which would exclude the application to the media. We don't, Mr. Zuma contends that the interpretation is one that would immunize journalists from violations, and that's not contrary to section 9 of the Equality Clause. That's not the interpretation which we advance. What we say is that it's the nature of the document, i.e. a public document, that is critical, and it's not about the identity of the possessor. It's not a question of treating people equally, it's about treating documents which are different appropriately. My lord and my ladies, that concludes the submissions to which the Amicus intended to address. My lord and my ladies, I haven't, like my learned friend Ms. Hoffman, I haven't addressed the question on permission. We understand that to be a resolved matter, but should it arise, I would likewise like to present, should it become an issue, on why it is that we warrant admission and have been admitted. My lord and my ladies, to the extent that there's any lingering question of costs from the last order that was granted, my lord and my lady will recall that costs have been reserved on that occasion. We don't intend seeking costs. The ordinary principles of the Amicus would be entitled to pursue a costs order. And that's notwithstanding that the agreement for us to be admitted as amici was particularly belatedly made after a full opposed appeals not taken place previously and being sent down to be heard, including the filing as well. We don't intend to pursue it in cost of order.
Thank you, Justices. And then there was Democracy in Action, the fourth amicus in the Maughan application only. The submission we shall make relate only to the Maughan application, and we do not make any submissions in relation to Mr. Downer's application. First, I need to start with an apology, which is usually starting with a back foot in doing submissions at this late hour in the hot afternoon in a court. We have already circulated a much abbreviated version of our argument to our learned friends last night. What it does is it limits our focus to only 3 issues. Your Lordships and Lady would have seen in our founding affidavit, DIA's founding affidavit, we list about 20 topics that we said we will address. You'll be happy to learn that that has been reduced substantially to only 3 points, and the 4th one being simply introductory by way of a context. I beg leave to hand up, it only runs to about 13 pages. I apologize for burdening you further. But it's all for a good cause, I would hope.
It's a 30.
1-3. Justices.
So what did you do with the previous sentences?
You keep the previous. This is not a replacement. It's merely a supplementary affidavit. Not affidavit. Supplementary set of oral argument that seeks to supplement the heads of arguments, the 29-page heads of argument that we've already submitted. It's perhaps important, since we appear here as an amicus, and we like to think par excellence, in other words, as quintessential amici or amicus. By making a correction, our learned friends for Mr. Zuma in their heads of argument in paragraph 4, in relation purely to the amici, you'll have seen they've submitted 2 sets of heads. In the set of heads that deal with the amici application, they say in paragraph 4 that the DIA, and I quote, makes it clear that it supports the continuation of the private prosecution. We do no such thing. applied, or the DIA applied, to be joined as an amicus curiae par excellence with a view to advancing the arguments on points that are set out in paragraph 17 of the DIA's application to be admitted as amicus. So it is important that we correct that impression. And so we've listened very carefully to our learned friends for the media amici, whose attributed arguments to us, which are made in or foreshadowed in the founding affidavit. And this is where it is also helpful to have submitted the much abbreviated version for oral argument purposes. She would have seen, if she had read our note carefully, that much of those arguments have now been left to Mr. Zuma, because Mr. Zuma's counsel appear to have taken on a large chunk of those 20 submissions that we sought to make. And so for purposes of this afternoon, we confine ourselves to only 3 points. The first deals with Section 9 of the Constitution. It locates our argument in Section 9 of the Constitution, which, as we all know, guarantees the equal promotion, protection, and benefit of the law to everyone. The second point is the interplay between Section 16(1) of the Constitution on the one hand and the Section 10, human dignity, privacy, Section 14, and access, right of access to court, Section 34, on the other. I have also listened, or we have also listened carefully to our learned friend from Moore this morning, where he appears to make a clarificatory remark, saying that we seem to misconstrue their argument, if I understood him correctly, as saying that their argument is that Section 16 is an impenetrable shield for a journalist, if I understood him correctly. Of course, incorrectly implied, if I'm incorrect in my understanding of what he said. And so he says our argument, or their argument, is not that Section 16(1) is an impenetrable shield for a journalist in relation to criminal cases. We appreciate that clarification, but it is important to address the issue nonetheless, because in paragraph 8.3 of their heads of argument, the court will find that one of the 3 bases upon which Ms. Moore launches her interdict and review application is that, and I quote, that Mr. Zuma's private prosecution constitutes a violation of Mr. Zuma's duty to respect the right to free media protected under Section 16(1) of the Constitution. We couldn't find anywhere in the heads, perhaps we didn't read them as closely as we should have. Again, Mr. Butlander will probably correct us if we missed it. We couldn't find in the heads an instance where that submission was ameliorated. In other words, was, what's the word I'm looking for? Supported. Now, it is supported, but where it is, sorry? No, not abandoned. The English language is escaping me on a Monday afternoon. Where it is attenuated is the best word I can come up with. So we deal with each of these 3 points in turn, but we believe that the starting point should really be the context. Counsel for the media, Amici, was careful to give you her client's preferred context. She prefers to see this case from a gender prism, which is her client's, right? We see it from a socio-political prism, particularly race and popular narrative. And this will become clear during my brief submission. We say it would be a mistake to consider Ms. Maughan's application outside South Africa's socio-political context, where the views or socio-political narratives favored by mainstream media, of which Ms. Maughan is admittedly a part, and the personalities associated with them can do no wrong. That is the context in which we wish to place this case. And so we begin with that context. Ms. Maughan is no ordinary litigant or citizen seeking to assert her rights. As the former public protector is wont to say, she is no Gogo Dlamini in some backwater village in Umlazi. She is at the forefront of mainstream media in shaping the socio-political discourse in South Africa as a journalist. What she writes is news. With a following of almost 500,000 on Twitter, she has a wide and penetrating reach. And with the backing of mainstream media colleagues, such as our mainstream media Amicus makes plain, the persuasive force of her views, regardless of merit or truth, is guaranteed. That is who we have before the motion court today that seeks to have her criminal prosecution stopped. Now, stripped of all the legalese and Orwellian English, this case really comes down to one question, phrased in various ways. This case is about a journalist who seeks absolution from a criminal charge. Why? Because she's a journalist. Hence the reliance on Section 16(1) of the Constitution. Because she's a journalist, secure in the comfort that she has the entire mainstream media machine behind her, as demonstrated by the first three Amicus curiae, which you would have seen have issued media statements in support of Ms. Maughan. So the principal question that these courts need to answer in our respectful submission is this: is Ms. Maughan entitled in motion proceedings within the bounds of South African law to avoid answering a criminal charge regardless of its merits? Is she entitled to avoid answering a criminal charge in a criminal court by reason only of her being a journalist and relying on Section 16 of the Constitution for that purpose? Put differently, does Section 16 of the Constitution provide an impenetrable shield for a journalist when she is charged criminally, whether by the state or by the private prosecutor? Does freedom of the press and other media in Section 16 of the Constitution provide such impenetrable shield? In other words, does Section 16 free expression or media right or media freedom right provide a complete defense to a criminal charge against a journalist, not in criminal proceedings themselves, but in antecedent motion proceedings? Thank you. A related question to this is this, and let me hasten to say we are not addressing that question. That is the question that Mr. Zuma, if there are heads of argument, any indication, seems to be addressing. it is this related question. Which court must answer that principal question? In other words, in which court must Ms. Maughan plead her free expression or media freedom defense to the criminal charge she faces? One would expect that the answer, yes.
But I understood the argument to be that issue in respect of the application of Section 16 is exactly what they are not saying. They are not saying she's protected by the issue of being a journalist and therefore she cannot be criminally prosecuted. That's what I understood the argument to be.
I understood the argument to say that Section 16 does not provide an impenetrable shield, but they rely on Section 16 to say that Mr. Zuma is bringing the private prosecution against a journalist in order to stop her from doing her work as a journalist. So the word I was looking for earlier was there is no qualification in the making of that submission in paragraph 8.3 of their heads of argument. And so, I'm sorry.
Because I understood it to be, it's actually not about her, it's about the public.
Yes.
About the public, having access to that information, and not specifically about her being shielded.
Well, I understand their argument differently. And certainly the media, Amicus, seem to understand the argument as relating not to the public primarily or principally, but to Ms. Maughan, because the reliance is then, or the context that is painted, is the context of gender. It's an attack on a woman journalist.
Yes, that is their argument, but her argument was different. I'm doing my work for the benefit of the public, and the public deserves to have that information, and I'm now being barred, sort of like barred, prevented from doing my work through private introduction of this private prosecution, which is basically.
Yes, no, I understand that, Justice Basika. The only point we are making is that, as we understand Ms. Maughan's argument, is that I am a journalist. I am covering cases in which Mr. Zuma is involved. And Mr. Zuma seeks to distract me from doing my job as a journalist. And therefore, that attempt is deprecatory, is to be deprecated and stopped by this court because it's in violation of Section 16.1. That's how we understand the argument. Yes, the public is important.
We noted your understanding of the argument, and we also noted the other side's understanding of it.
Thank you, Justice Peter. Thank you, Justice Peter. Well, that concludes that little part. But we say that we're not dealing with that issue, we're just highlighting it. But, and we say counsel for Mr. Zuma addresses this issue and we don't address it. However, it is important in this context to remember the High Court or the full court decision in the Johannesburg High Court, where similar arguments were raised. I'm not sure if it's in anyone's bundle of authorities, but we have, it's not in our authority. It's a case of the President of the Republic of South Africa versus Zuma and others. And the neutral citation is square brackets 2023 ZAGPJHC ZAGPJHC 11. Thank you, Justice. I appreciate it. That court has made a determination as regards which forum a litigant who says that she's facing, in this case it was the President, facing an unlawful prosecution can attack that prosecution. It said, as you would have noted, that the president was entitled to approach the High Court other than the criminal court in which he is charged to set aside, well, in this case it was an urgent interim application. Part B review is still coming. But we say, even if that court, well, let me phrase it this way, the judgment of that court, at best for Ms. Maughan, is merely persuasive. Maybe I shouldn't say merely, is of persuasive value, nothing more. This court is entitled to come to a different conclusion. And in any event, we say, again, we're just highlighting it, we're not addressing the point directly. Our own view is that the court judgment or decision is mistaken. And we shall demonstrate this in passing by reference to the position in Canada. For now, we only point out that the reasoning in paragraphs 8, the court could make a note, paragraph 8 and paragraph 19 of that judgment seems to be at odds with a judgment of the Constitutional Court in the State Capture Commission. I'm paraphrasing, it's got a long title. It's the State Capture Judgment versus Zuma. That one is reported, and it's also not in our bundle. It's reported at 2021 volume 9 of the Butterworth's Constitutional Law Report, page 992. It's also recorded in the South African law reports at 2021 volume 5, SA 327, where the Constitutional Court in that case had directed Mr. Zuma to appear before the State Capture Commission, notwithstanding his challenge in the High Court to the legality of the proceedings, by reason, he says, of the chairperson being conflicted and lacking partiality. Yet the Constitutional Court saw nothing wrong with, and I say this with respect, I don't mean to be disparaging, to disregard the pending High Court application to review and set aside the refusal of the chairman of the State Capture Commission to recuse himself. And it went ahead, heard the application by the chairman, and handed down a judgment that says Mr. Zuma must be imprisoned for failing to obey the Constitutional Court's earlier order that he appears at the State Capture Commission. Now, the question that arises here is, I don't want to read the paragraphs 8 and 9 and 19 because we've cited it in our short note. In the interest of time, if our courts are true to equal protection and benefit of the law, which is the point we are going to next, then the president's interdict challenge, like Mr. Zuma's High Court challenge to the legality of the State Capture Commission, should not have prevented his appearance in his criminal trial. So put differently, what's good for the president should have been good for Mr. Zuma. Let me recap. The Constitutional Court, and I'm paraphrasing, said to hell with the interdict application or review application of Mr. Zuma. We are going to go ahead and force him to appear before the State Capture Commission, even though he says that process is unlawful. Why should this court treat Ms. Maughan differently? She is doing exactly the same thing. She's coming to this court to ask it to interdict her criminal prosecution and to review it and set it aside. The Constitutional Court said to Mr. Zuma, no, you can't do it, despite his concerns about the legality of that state capture process. All we are saying is, and importantly, is what's good for Mr. Zuma must surely be good for Ms. Maughan. And so with that, we go to that equal protection and benefit of the law aspect. We say Ms. Maughan's attack on her criminal prosecution is no different from that of Mr. Zuma more than a decade ago in NDPP versus Zuma. It's a 2009 judgment of the Supreme Court of Appeal. Now that does appear in our bundle. It's a B1, item 3, at page 75, if the justices could make a note. I needn't go there. The only difference is that Ms. Maughan is a journalist. When Mr. Zuma was the ruling party's deputy president, who had been ignominiously fired by the president as the deputy president of the country. The other difference is that she is a woman, where Mr. Zuma is obviously a man. The third, well, I've already said that she is a journalist. So the question that then confronts this court is this: does Ms. Maughan, to use the phrase to which our learned friend for the media amici intimated, does she get a get out of jail free pass just because she is a journalist who enjoys the support of her peers in mainstream media? Must the courts treat her more favorably than it did one who is neither a journalist nor a woman? All these questions, and of course there is the ever lurking specter of race in all of this. There is an ever lurking specter of race. Noticeably, Ms. Maughan is also a white person in South Africa, while Mr. Zuma is a black man in South Africa. All these questions will ring in the minds of ordinary South Africans, and rightly so, given South Africa's recent socio-political history. Justices, and this must be said, whether we like it or not, Ms. Maughan's race as a white South African will be important in the determination of this case. And I pause. But then add that not in the minds of this court, obviously, because the courts are expected to be above race and popular narrative considerations. But ordinary people out there will look at judgments of the courts and wonder, why is this case treated differently from another case in similar circumstances? I'll make two examples of this. But before I get there, another important consideration which this court must bear in mind as it assesses Ms. Maughan's application is the one to which I intimated earlier, the decision of the Constitutional Court on the 29th of June 2021, where Mr. Zuma was directed to appear before a process that he had challenged as on the basis of legality. Now, there are two touchy examples of prosecutorial, what I call prosecutorial inertia in South Africa. It is the appearance of it rather than the factual basis of it. This is what we seek to emphasize. It is regrettably an open secret that some prosecutions are pursued or appear to be pursued with greater vigor than others in South Africa, seemingly depending on the political will of those who make those decisions. For example, to date, the apartheid murderers of the Craddock Four, who were killed, mutilated, and burnt in 1985, have still not been prosecuted to date, notwithstanding a statutory injunction in the form of the TRC Act that says those who either applied for amnesty but failed, or those who did not even bother to apply for amnesty must be prosecuted. There appears to be no political will to do it. No non-prosecution certificate has been issued either. And an NDPP in the form and shape of Advocate Vusi Pikoli appears to have been the victim of this, for going against the political headwinds of the time. Prosecutorial inertia. Another example, and this is the last example I will make. Not so long ago, a high-powered panel led by a former Chief Justice Ngobo, no less, found that the number one citizen has a case to answer in relation to including criminal liability. Merely a case to answer, not that he's guilty. This was an issue that the prosecuting authorities should have looked into. Certainly I, looking at it with a trained legal eye, I couldn't find any reason why one couldn't find a prima facie case to bring a prosecution case in those instances. Now, one is not saying the president is guilty or anything, but a case to answer. It was not an issue to be resolved in Parliament by members of Parliament who seem to owe fealty to one of their own. Those are just two examples. There is a third. In 2017, two white males were found to have defrauded the University of Johannesburg of 25 million rand. To date, we haven't heard of any prosecution. Instead, the university issued a media statement saying they have filed criminal charges, they have gone to the Joburg High Court for payback of the money. But neither criminal charges nor nolle prosecution certificate. Prosecutorial inertia. And so the simple point we make, justices, is in the eyes, perhaps not in the eyes of the court, or certainly not in the eyes of the court, but in the eyes of the general public, who are not trained to discern the nuances of law and legal machinations. They will see a set of facts in relation to a white female journalist, look at a set of facts in relation to a black former president who is a man, look at circumstances where two white senior members, because the one was a former, vice chancellor of finance, and the other was a chairman of the council, how there are virtually no criminal consequences for them. And yet, a student at Wits, into whose account the university funding program paid 14 million in error, was promptly prosecuted. All this plays in the minds of the general public, and they ask themselves the question, who is to say that race had nothing to do with this? Now, that is both the context and the equality before the law and protection of the law aspect of DIA's argument. We now go to the next issue, and I'm not going to dwell on it. And that's the issue of the interplay. It's the second issue of three. the interplay between the Section 16 media freedom right on the one hand and the human dignity and privacy rights on the other. We make a simple point there by reference to only two cases, Mamabolo and Kumalo. And the only point we make is that the Section 16 right, the counsel for Ms. Maughan will deal with it in her reply if we misunderstand the argument, but an argument we will make nonetheless, is that Section 16 is not an absolute shield. It has to be weighed up with other fundamental rights. In Mamabolo, for example, and we cite this in paragraph 21 of our short note, in Mamabolo, Justice Krikla, I think it was, said the right to freedom of expression cannot be said automatically to trump the right to human dignity. The right to dignity is at least as worthy of protection as is the right to freedom of expression. What is clear, though, and must be stated, says Justice Krikla on behalf of the Constitutional Court, what is clear and must be said is that freedom of expression does not enjoy superior status in our law. And in Kumalo, the Constitutional Court set out the importance of freedom of expression and the obligations of the print, broadcast, and electronic media in that respect. But where I want to focus is what's reproduced or paraphrased in paragraph 22.5 of our short note, where the Constitutional Court said, as primary agents of the dissemination of information and ideas, the media, of which Ms. Maughan is one, are inevitably extremely powerful institutions in a democracy, and they have a constitutional duty to act with vigor, courage, integrity, and responsibility. You can't just hide behind the Section 16 freedom of the media, right, when you are being accused of having breached Section 41(6) of the NPA. It went on to say, the manner, and this is 22.6, the manner in which the media carry out their constitutional mandate will have a significant impact on the development of our democracy, of our democratic society. If the media are scrupulous and reliable in the performance of their constitutional obligations, they will invigorate and strengthen our fledgling democracy, of course. But if they vacillate in the performance of their duties, the constitutional goals will be imperiled. Without saying whether Ms. Maughan is guilty of that of which she is being accused, one cannot, in our respective submission as an amicus, one cannot say that a journalist can hide behind the right to free expression and the right to media freedom and take that to the High Court to stop her facing a criminal charge in the criminal court. And finally, on this aspect, in 22.7, this is what the Constitutional Court had to say in Holomisa and Kumalo. Although freedom of expression is fundamental to our democratic society, it is not a paramount value. It must be construed in the context of the other values enshrined in our Constitution. In particular, the values of human dignity, Section 10, freedom and equality, Section 9. We submit as the amicus that this court's heavy burden is to perform the balancing act between Ms. Maughan's right to free expression and media freedom on the one hand, and on the other, Mr. Zuma's right to human dignity, privacy, and equality, equal protection and benefit of the law. That effectively is the exercise that this court is called upon to perform. Now, I want to jump head on to the non-prosecution requirement. But before doing that, this is an important point to make in conclusion on this second part, which is the interplay between Section 16 and Section 10 and Section 14 and Section 34. It is that if this court were to grant the interdict and review application sought by Ms. Maughan, we submit with respect that it would thereby be allowing Ms. Maughan, the rights of Ms. Maughan under Section 16, to trump all the other rights enjoyed by the object of her conduct. And that is in the form and shape of Mr. Zuma. It could have been anyone else. Now, the non-prosecution requirement. The DIA asserts that the non-prosecution certificate may very well be an impediment to a private prosecution in Section 34 of Section 34, right of access to court. Especially, this is the important emphasis, Justice, especially where a recalcitrant prosecuting authority declines to prosecute an otherwise prosecutable case. I've given you examples.
I don't think you will find anyone that will disagree with you.
Thank you, Justice. So I need not dwell on that issue. But it's only an opening, I almost call it a salvo, but salvo has elements of attack to it. But it's merely an introductory opening to the various submissions that we wish to make under this rubric. Other developed nations, so let me take a step back. We understand that a non-prosecuting certificate is a prerequisite. Mr. Butlander calls it a jurisdictional prerequisite for a private prosecution. That is correct, both in fact and in law. But we say if the courts are to be true to these competing rights between Section 16 on the one hand and the three other rights, human dignity, privacy, and access to court, then a court should not be supine to a recalcitrant prosecuting authority refusing to issue a non-prosecuting certificate, thereby forestalling the bringing of a private prosecution. Let me explain this. In New Zealand, a judge, not the prosecuting authority, decides whether a private prosecution should be conducted. There is a good reason for it. In India, a magistrate, and the good reason, of course, is that a judge is impartial. The NPA, in terms of the NPA Act and the Constitution, and I cast no aspersions on them, they serve the country well, on most occasions, is the personnel there, the senior personnel, are appointed by politicians. The Vusi Pikoli incident is a perfect example of where there could be political interference in the running of the NPA and in the decision making as regards who gets prosecuted and who doesn't. This is the subject of the Ginwala Commission report, for example. And so, both in New Zealand and in India, are impartial persons in the form of a magistrate on the one hand in India and a judge in Canada make the decisions. It's not left to the prosecuting authority. In Canada, which is where I wish to dwell for a moment, the Crown Attorneys Act of 1990 assigns a duty on the Crown Attorney, which is an equivalent of a DPP in South Africa, to, quote, watch over cases conducted by private prosecutors. They have to keep a watch on it. Because prosecution is the domain of the prosecuting authority. That is why the public prosecutor in Canada has to keep a watchful eye. So there is no abuse of the process. And it's an elaborate process, as I will explain in a moment. The Crown Attorney may only interfere by taking over the conduct of the prosecution where justice towards the accused demands. And that is where they take over. A private prosecution does not come about in Canada on the whim of the public prosecutor deciding whether it's going to grant permission or not for the private prosecution to continue. The process in Canada, and I asked the justices to make note of this, although it's in our short note at 29.4, paragraph 11. Private prosecution process in Canada is usefully narrated in the Court of Appeals judgment of McHale, which you'll find in bundle 4 of our bundle. And I've set out the various pages where you'll find it when you read it in your own time. Assuming, of course, there'll be a reserved judgment. The judgment is not going to be made immediately. The relevant provisions are also set out where the court will find them in B4. The process begins, this is quite important, the process begins with a sworn statement of the alleged offense by the private complainant. Then follows a stage they call a pre-enquête, something like a mock trial, which is presided over by a judge in camera and is brought on an ex parte basis, where the judge tests the strength of the case or the reasonableness of the charge in chambers, only with the complainant. The public public prosecutor is also invited to be present in those proceedings and is permitted to cross-examine the complainant and his or her witnesses to test the prima facie basis for the private prosecution. That is to weed out any frivolous and vexatious prosecutions before it goes to court. Well, presumably the judge who sits there is not the same judge who's going to be hearing the main criminal case. That process is set out in the McHale judgment of the Court of Appeals in Canada. The point is this: in Canada, the conduct of private prosecution is not dependent on the Attorney General or public prosecutor granting a permission. I should say en passant that it is worth noting that in Canada, only the Attorney General, I imagine it's the equivalent of the NDPP, only the NDPP or the DPP has the right or the power to stay a private prosecution. No person against whom a criminal charge is preferred has a right to approach a court to stop it, as it's happening here. There must be a reason why the Canadians thought it wiser to leave such decisions to the prosecuting authority, not to the person against whom the complaint lies. And you will see this also in the McHale judgment. It's not a long judgment. It's only, I think, about 90 paragraphs. And so, justices, in conclusion, we make these submissions not with a view to saying that there's anything unconstitutional about Section 7.2, lest we get attacked for that we are attacking Section 7.2, but we haven't filed an application declaring it unconstitutional. One doesn't have to file an application declaring 7.2 unconstitutional. We're not saying Section 7.2 is unconstitutional. Perhaps Mr. Zuma in different proceedings may do that, but we're not doing that here. What we are saying is this court should be guided by what the position is in other comparable constitutional democracies when investigating or assessing the application by a person against whom a criminal charge lies, coming to the High Court to stop that criminal prosecution. We therefore, in conclusion, we're not seeking any relief. We simply ask that the court, when it considers Ms. Maughan's application, consider the general South African socio-political context in which the application arises, that it considers the right to equal protection, the interplay between the Section 16 right and the other rights held by Mr. Zuma, that it considers the equal protection and benefit of the law right, and that it considers the position in other comparable constitutional democracies. If I may take soundings to find out if I've messed up or missed anything. Justices, those are our submissions. Unless there's any points of clarity, I'd rather have them now than discover them for the first time in a judgment.
I'm trying to understand what you're saying is wrong with our system. Starting with the issue of the issuing of the non-prosecution certificate. So if someone wants a certificate and it's not issued because they're having problems with the Director of Public Prosecutions to get the certificate, they have a recourse of approaching the courts to compel them to issue a certificate. And the court will consider and make a determination of whether or not order that it be issued. Similarly, in respect of the last issue, I'm going to say, just make an example with Ms. Maughan. She has approached the court because she wants the court to obviously satisfy the private prosecution. So what I'm saying is, in terms of comparing our courts with other jurisdictions that you're referring to, we obviously have a different system which is guided by our constitution. In my view, it actually provides a little bit more latitude and allows for the courts to be accessible to people so that they could challenge and or raise whatever issues. This is what you said, that the Attorney General is going to be the one who's making the determination. Yeah, courts are available, accessible to anyone. If you're on the other side, you can approach the court. If you're on the other side, so what I'm trying to understand is what is wrong with our system, the way that it is.
I'm sorry,
Justice must
before you answer that, to add to that, we have a full court decision in this division which says the NDPP doesn't have a right to refuse to issue it, doesn't have a right to analyze whether there's an actual injury suffered or not. They are required to issue that certificate. So in the context of that, could you answer my sister Masika's
Thank you, Justice Hendricks and Justice Masika. A friend of mine in the advertising space once wrote that justice is available. Well, justice is like the Hilton Hotel. It's available to anyone who can afford it. That is the problem with having a person having to approach a court in order to assert the sort of right that we are talking about. What of a person who is a man or woman of straw, who has nothing to put together with a view to approach a court to compel the NDPP to issue a certificate? What the beauty about the Canadian system is that it takes that burden away from the ordinary folk and puts it in the hands of the prosecuting authorities.
Well, but my sister just said there's a judgment here that says they would issue the certificate. So that's the first thing. The second thing is we have a whole lot of different legal institutions that would aid people who cannot afford.
If they are willing to do so. I mean, I'm sagging under we're doing this case pro bono, for example, but we can only be stretched this far. It is not everyone. I say this with the greatest respect to my profession. It's not everyone who is falling over themselves to take on cases on a pro bono basis, to go to court and to go to the High Court and then go to the full bench and then go to the SCA and then go to the Constitutional Court.
But perhaps your comments are misdirected. You should be directed to the Bar Council and your colleagues.
No. I'm making a different point, Justice Kruger. That it makes eminent sense for the decision, I'm coming to Justice Hendricks' question to me, that the prosecuting authority doesn't have the latitude to refuse to grant a Section 65, a non-prosecution certificate. But we all know the law provides one thing, human beings do another, for all manner of reasons. And so to say the law compels you to do this doesn't necessarily mean that the people who are holding those positions will do as the law requires. I've given you 3 or 4 examples of where, as Justice Hendricks says, the prosecuting authority is compelled to issue certificates where no such certificates have been issued. Of course, I don't know whether there has been a request for those to be done, but the starting point is an imminently prosecutable case has not been brought forward. Who knows what the reasons are? I'm saying the ordinary person in the street will look at this and compare cases that are seemingly similar, in fact, and then come to a conclusion that no, and there's a famous or infamous tune that is now being sung that no, the NBA is captured. We don't want to get there. And to avoid all of that, we're not saying the South African system is unconstitutional. We're simply saying that the courts should use its just and equitable power to intervene without an application having to be made by the affected person. It should be the NPA that should be driving that process. Other than that, I can't take it further. Well, let me not say that, because usually when counsel says I can't take it further, they throw it in the towel. That is the sum total of our response to the questions posed.
Thank you, Mr. Mayor.
Thank you, Justice. Thank you, Justices.
See, it's now 24, Mr. Hopefully we can have the day of tomorrow and consider all these submissions.
Thank you very much, Justice, Presiding Judge and Justices. Well, as it happens, it was going to be my learned friend, Mr. Masuku, for various reasons, including on a lighter note, the fact that I was forced to come here today by my client. Otherwise, I would have only fielded Mr. Masuku, but I relented because of the color of his tie. But on a more serious note, Justice Kruger, the next person in the betting lineup would have been Mr. Masuku. I don't know if the court might want him just to lay the basis or simply to let's start afresh on fresh minds and hopefully better air conditioning on. Thank you.
Sorry, Justice.
Oh yes.
Before I start on Wednesday, I really would like to apologize for the condition of our first set of heads of arguments. We subsequently cleaned them up, and in the sense of grammatical mistakes that were there, sometimes we didn't refer to authorities, but we quoted judgment of the Constitutional Court without referring to an authority. Those are the heads you have. What we now have are authorities where we have cited the authorities on which those quotations come from. We would really like you to look at these heads of arguments rather than.
We propose we do that now that we've read everything and we're ready for argument and in fact
No, it's really up to you. Remember, our heads are prepared for benefit of the court.
Yes, so why wasn't it done in the first place?
Well, it wasn't done. That's why I started off with an apology. So, yes, we're under a tremendous amount of pressure with a number of things. We even have an application for condonation. If your lordship wants us to do this.
I can see I'm trying to get an answer out of you. We'll be here till 6
until Wednesday. I thank you, my lord, for the honourable court for the indulgence. We also have attached our authorities in the papers. Thank you.
My lord, could I say this is the first we've heard of these heads? We haven't been given them as a copy. We'll have to read them and consider our position. I would have thought as a courtesy they would have been delivered earlier.
That is absolutely incorrect.
Well, that's the best. I don't know which set we're on, but I'm just telling you what my position is.
No, that's absolutely not correct. My learned friend is not speaking correctly here. They do have a second set of heads which were sent to them day before. I mean, on the Friday. They do have the second set, but if they don't have certain sets, all that it has is really corrections that are stylistic, and we refer to authorities in the first heads where we don't. That's all we do really.
My lord, let me make it clear. I have no objection to them going in. I'm just saying that I'm not clear what's in those files, and we'll consider our position tomorrow and spend the public holiday doing so.
Consultation with my colleagues here. Where you have omitted to make reference to case law, you can then refer it to us and we will amend the heads that we have. Because we've made notes now, so to go back and to start changing notes all over again, I think it's an untenable situation. Where you have made reference to case law, which are not on the previous heads, you can notify us and we will mark it. Court will adjourn to
My lord, could I inquire, are we commencing at 9:30 on Wednesday? I apologise.
Yes, 9:30 is when court starts.
Thank you, my lord.
Yes, sir. I'm sorry, they are asked to be excused for Wednesday. I have to relieve my wife. I'm sorry, Justice.
You don't want the right to reply?
As an Amicus, I didn't think we were entitled to it, but my learned friend will be here. I have to relieve my wife back at home. It's a previous already.
We will excuse you for Wednesday.
Thank you.
Is there anything else? Court will adjourn.
No, of course not. Oh, yes.
We'll read the file over my holiday.
Because of
Yeah.